Where am I going?
Oh, yeah, yes. It was like, bye boy. Yeah.
Mhm.
Good morning and welcome back to docket number 250403. We are here this morning for oral arguments in this matter. A couple of notations before I take appearances. We'll take appearances for the purpose of understanding who would like to participate in oral arguments this morning. As a reminder, the evidentiary record in this matter has closed, so the purpose of today's oral arguments is to receive just that oral argument from any party or intervener with respect to the question before the authority at this time. This is not an opportunity to introduce new evidence, but rather to go through your arguments with respect to the record that is before the authority. So if I could ask any attorney representing a party or intervener who intends to participate in oral argument this morning, if you could please approach the mic and state your name and the party on behalf of whom you will be presenting argument.
Good morning.
Morning.
Can you hear me?
You might want to tilt it up a little bit, please.
Good morning.
Morning.
Robert Hum on behalf of Eversource Energy and Aquarion Water Company.
Thank you.
Good morning, Daniel Canavan on behalf of the South Central Connecticut Regional Water Authority.
Thank you.
Good morning, David Ball, representing the towns of Fairfield, New Canaan, Ridgefield, and Westport.
Thank you, sir.
you.
Good morning.
Good morning, Madam Chair. Tony McLeod, representing the Connecticut Metropolitan Council of Governments. Thank you.
Thank you.
Good morning, Allison McCorney for the Office of Consumer Counsel. I'm joined today by Consumer Counsel Claire Coleman, Legal and Regulatory Director Tom Wheel, Albert Zablowski, and Rich Sobolewski.
Thank you. Good morning.
Good morning, Caroline McCormick on behalf of the Office of the Attorney General. I'm joined here by my colleague, Assistant Attorney General John Wright. Thank you.
Thank you. Are there any other attorneys or representatives, parties, and interveners that wish to participate in oral argument this morning? If not, I think that was a natural order for which to present argument this morning. So we will do 2 rounds. And I will invite Attorney Hum to present argument first, please.
Thank you. So first of all, thank you for scheduling this oral argument. We've read the briefs and we understand that there are still some concerns and there are still some misconceptions with respect to this transaction. And we get it because it's complicated to move from one form of regulation to another form of regulation. So Mr. Canavan and I are here so that we can address those items, that we can answer any questions that the bench has with respect to any of the issues that have been raised in this proceeding. And to the extent the questions are so detailed and technical, we also do have our subject matter experts here today. We have Ms. Kowalski, we have Ms. Texera, and we have Mr. Norman, and they're prepared to assist in any way possible to answer questions if they can. So the key to this transaction is first that it meets the statutory standard of approval, and it's in the public interest for the AWA to own Aquarion. And the fact is that this transaction is in the best interest of customers. This is the best transaction for customers. This transaction benefits customers in ways that no other transaction possibly could. And frankly, even more than the status quo possibly could, given the benefits that customers are due to experience if the transaction is approved. And we'd like to explain today why this unique transaction under the authority model benefits customers. And in order to do that, I do point out that there are two overarching issues that were commonly raised in the briefs by the interveners. Of course, there are lots of sub-issues and smaller issues, and we can take questions on those as they come. But the two overarching issues that we've picked up on, number one, the interveners argue that rates will increase under AWA ownership. And number two, the interveners don't like the governance structure if the transaction is approved. So I'll address both of those, and again, please ask questions at any point. With respect to the rates, the best way to look at this transaction is that it's a refinancing of Aquarion. Aquarion as an operating company is staying in place. It's as if Aquarion is buying Aquarion and it's refinancing its outstanding capitalization and enterprise value with publicly bonded debt. And that publicly bonded debt is going to be held by the AWA. And it's going to be paid for with Aquarion's own existing revenue stream. There won't be any rate increases that are caused or that are needed to cover any of the acquisition costs. The current revenues are sufficient to cover this transaction. The acquisition costs are simply a refinancing of Aquarion's existing enterprise value. So on day one, post-closing, there are no rate increases. The rates are going to be exactly the same. Now, at some point in the future, rates are going to increase, whether under AWA ownership or whether under Eversource ownership of Aquarion. And when rates do increase, it's not going to be because of this acquisition or any of the acquisition costs. It's going to be because of the capital investments that are necessary and required over the next many years. And when rates do increase, those rate changes are in the best interests of customers under the AWA model. And there's no doubt about it. If there's anything to remember that comes out of this transaction, it's that for every dollar spent on those capital investments, it's cheaper under AWA ownership. That's a significant benefit to customers, and that can't be matched by any other transaction. And here's why. So the information in the record shows that there's a need for approximately $2 billion of capital investment over the next 10 years. And that's to address requirements such as PFAS, the lead and copper rule and revisions, WICA replacements, and other investments. For Aquarion, when Aquarion owned by Eversource or an investor-owned utility, for every dollar spent, that revenue requirement includes equity and debt costs of capital. And that results in an equity return, and it results in a higher cost of debt. It also includes federal and state income taxes. For every $100 million spent for Aquarion infrastructure under Eversource ownership, that equals approximately a $12 million revenue requirement. For AWA, for every dollar spent, the revenue requirement includes only the cost of debt. There's no equity return, and there's no federal or state income taxes. So what that means is that for every $100 million spent, that equals $9 million of revenue requirement. On top of those savings, because there's no equity investors, there's no dividends to pay to those investors. All of the money stays within the AWA and Aquarion system for future reinvestment, for future benefit and savings to customers. So therefore, again, for every dollar spent on capital investment, customers will pay approximately 25% less under the AWA model. And again, that's a significant benefit to customers that cannot be matched. And that can only happen if the transaction is approved. If the transaction is not approved, then customers won't receive that benefit. So that's with respect to rates. And again, I'm happy to answer any questions about some of the related issues on the rates. The other issue, the overarching issue that I mentioned, is the governance structure. And on the governance structure, the statute is set up the way that it is because it recognizes that there's a need for a transition period when you're going from one model to another model. And that's needed for the AWA to gain expertise and experience post-closing. And that's important here. It's important to ensure that the transaction is successful so that you have that transition period post-closing. That's what the credit ratings are based on, and the credit ratings are favorable to the AWA and therefore favorable and benefit customers. And in fact, the AWA's indicative credit ratings are better than Aquarion's credit ratings under its current ownership with Eversource, and that benefits customers. There's every intention that the AWA communities are going to be making decisions regarding the AWA to have a successful transaction and transition. And we've tried to emphasize this throughout the course of the proceeding and throughout the briefing. The AWA Representative Policy Board, the RPB, they're the economic regulator. They make all the economic decisions on behalf of the AWA, and they're made up of 100% Aquarion towns, plus the one representative appointed by the governor. And their responsibilities include setting rates. It includes setting rates. So the rates that customers are going to pay are set by the AWA RPB. So they approve rate applications, and what goes into those rate applications are their reviews of the budgets. And those budgets are reviewed and reviewed and reviewed over time. They're reviewed by the RPB. They're reviewed by the various committees under the RPB. They're reviewed by the OCA in its oversight role. All of that goes into the approval of the rate applications, and that's a thorough process that goes forth over the course of the year. It also includes whether projects over $3.5 million are approved and are going to proceed. Those projects and any other capital projects are also included in the budget that's reviewed over the course of the year through a thorough process. It also includes whether new bond issuances are approved. So all of the economic decisions that could impact the AWA and the Aquarion customers are made by the RPB. I'd also like to point out that the joint petitioners have committed to a conflict of interest policy that it'll file with the Attorney General's office and the OCC. And the joint petitioners plan to have a special transition committee that will work with the towns on things that they could potentially do, including things they could potentially do without legislative changes. With respect to that rate setting process that I mentioned and the OCA's role in the rate setting and how that rate setting process works, there seems to be a lot of uncertainty, and the uncertainty is because it's a different process. In many ways, you could argue that the AWA rate process is more thorough and more consistent than PURA's process or any state regulatory process, not just PURA. It basically flips around the process. So again, with the way that the current form of regulation works, the company comes in and it makes its filing, and nobody has seen it ahead of time. And therefore, you have this big filing that everybody's reviewing and they don't know what's in it. And you have a huge investigative process. And that's what you go through the rate setting process that PURA has. With the AWA model, it's flipped around. Again, that budget is reviewed over many instances over the course of the year. The OCA is integrally involved in that year-round process. The OCA regularly reviews the budgets. It regularly reviews the 10-year business models. All of those include the capital projects that are reviewed, that are vetted, that are amended over the course of the year. The AWA's financial plans are subject to monthly RPB meetings and review, and that also has participation of the OCA. The Finance Committee updates and it approves the quarterly financing that's presented to the AWA communities. Management presents quarterly financial reports. All of these address the capital projects. And all of this happens before the rate filing that's made before the AWA RPB. And every step of the way is a public process. It's all public. It's all out in the open. Everything is public, and people can participate, they can watch, and they can participate by making comments. So by the time the rate filing is made, it's been thoroughly vetted, reviewed, and if necessary, it's been amended before that rate setting process starts. So in other words, it's not a loss of regulatory oversight, it's just a different process. Now, I mentioned a moment ago one of the commitments that the joint petitioners have made. I would like to point out that the petitioners have included a list of commitments both in the initial brief and in the updated in the reply brief. And we're open to defining those commitments. We're open to enhancing commitments if necessary. We'd like to work with the parties. We'd like to work with anybody who's willing to work with the joint petitioners to enhance the commitments for something that makes sense. We're happy to sit down and work with the EOE too, if that's something that's of interest, because everybody wants to make sure that this goes through, and that if it does go through, that it's a successful transaction and a successful transition. So again, notwithstanding all that, we want to thank PURA and all the parties and stakeholders that have participated in this proceeding. And at the end of the day, the initial application, the discovery, the evidentiary hearings, and the late file hearing, the briefing, they all demonstrate that the transaction meets the statutory standard and is in the public interest in a way that no other transaction possibly could. So therefore, we ask that PURA approve the transaction. And again, we're here for any additional questions that the commissioners have. And we have some folks who can respond to some of the technical questions if you'd like. And we'd also like to reserve some time for rebuttal, as you pointed out in your opening remarks. Thank you.
Attorney Hum, you mentioned just a couple of minutes ago something about a transition committee, special transition committee. And the hope was that wouldn't need any more statutory changes. And it seems to me, based upon the briefs and all the evidence we saw here, that the biggest sticking point was the statutory construction and execution from the legislature, and how AWA has pretty much hung their hat on the fact that the statute says what the statute says that we wrote, and shouldn't be changed. And you indicated that you'd like to avoid any statutory changes. So I'll give you a chance to speak to that if you could.
Thank you, Commissioner Karen. And you do raise a good question. So the statute says what the statute says. That statute was approved by the legislature in 2004. We submit it was through a special session, but it followed the normal procedures that any other special session would. In order for that statute to change, it does need a legislative change. So that's not necessarily something that the joint petitioners can on their own commit to. That's something that requires work and collaboration among anybody who would be participating. And the joint petitioners have recognized the concerns and recognized the very concern that you pointed out, the work required to change a statute. And that's why they're trying to look for ways and work on ways so that you can make changes, and so that you can have certain decisions that could go forth without statutory changes. And I'll say that those are in progress. I'm not able to talk about any specifics today, not because I can't, but just because they're still in the process of being worked out. The parties are trying to work with each other. We're trying to work with the stakeholders, and that's one of the things that's in progress.
Thank you.
Okay, thank you. No further questions at this time.
Thank you.
Attorney Canavan, please.
Good morning. You guys hear me? Good morning, Daniel Canavan for the Southwest Regional Water Authority. Certainly, Attorney Hum has done a great job providing our view of the proceeding and why we believe that the application should be approved as filed, because we have met the standards in the statute that require the acquiring entity to have the managerial, technological, and financial ability to run the acquired entity. So without repeating everything that Mr. Hum has just said, I will leave you with a couple of thoughts from our perspective. And first and foremost, I think that is very important for all of us to acknowledge that this is a very unique transaction. Those of us who've been around here for a while are used to seeing change of control proceedings, but I'm not sure we've seen a change of control proceeding just like this, where we have an investor-owned utility divesting itself of a water company or utility to an authority. That is very unique, I understand, across the nation, but certainly very unique in Connecticut. And I think that's going to require us involved to review this transaction in a slightly different light than we otherwise may have when we see a change of control proceeding filed. There's some obvious differences, right? We have an investor-owned utility whose investors demand a return. They need to acquire capital to deploy to the service territory, and they require a return on that capital to provide safe and reliable service. The Water Authority does not require a return. This is a nonprofit entity. All the money it raises and acquires to run its operations stays with the entity. There is no investors. There are only customers. That is a large difference in this transaction that I would think we would look at other transactions slightly differently. So I think some of the issues that we've heard raised in this proceeding don't necessarily fit with the dynamics that are involved. It's certainly then when you look on to the lack of tax, you look at the cost of acquiring capital, all those become wildly cheaper for under the authority model going out into the out years. They have the same responsibilities to provide safe and reliable service. PFAS, WICA, all those things still require and demand attention from the utility, no question. This is the only utility where the product is consumed. So there is certainly a heightened awareness of providing safe and reliable water service to its customers. But when you look at the economics of this deal, it is wildly cheaper for customers in the out years under the authority model as compared to the investor-owned utility. Those of us who have been here for a while understand that no one walks through those doors and says, I can save $365 million for your customers going forward. It just doesn't happen. And the uniqueness of this transaction allows that math to take place. That allows that savings to run to customers where it cannot under an investor-owned utility. And for that reason, we think that even though there are concerns about rates in the near term, we believe that this transaction is in best interest of customers. I've also heard some questions about governance. I think those questions are, again, arise from going from an investor-owned utility to a water authority. But let's not forget that water authorities have been around for a very long time. RWA is not unique in that position. There are other authorities throughout Connecticut. There are other water authorities throughout the country. And those models all resemble, they're all probably different in some ways, but they all resemble what the water authority has here, where it has a governance model that's run by a board of constituents that represent the customers in their service territory. That model is not bad. That model is not evil. It's different than an investor-owned utility that's regulated by the state. There's no question it's different, and there's probably good reasons why it's different. But that does not mean that every water authority out there or the RWA can't continue to provide safe and reliable service to its customers, or in this situation, to customers that it intends to acquire from Aquarion. In a lot of ways, Aquarion is buying itself, and that's an item that Attorney Rob Hum said earlier, and that is very much true. At the end of the day, Aquarion is going to be operating much like it operates today. Same management structure, same customers, same customer service staff, same operational staff, same water flowing through the pipes to its customers. There's going to be largely no difference in the way that Aquarion operates after that transaction, if approved, will close. So we understand the governance issues. Attorney Hum identified that there are some concepts out there that would allow us to provide maybe some further guidance on governance without legislative changes. And I appreciate Commissioner Karen's questions on that point. And that probably requires further development. But despite all that, we believe that this transaction is in the best interest of customers. We believe the record shows clearly that RWA and the Aquarion staff that will leave Aquarion has a managerial, financial, and technological expertise to run Aquarion and provide safe, reliable service to its customers. And with that, I'll close my remarks. And if there's any questions from the commissioners, I'd be happy to handle them.
Attorney Canavan, since you reflected on having been part of other change of control or acquisition proceedings, maybe I can try your mind. In your opinion, is the public interest test that has been referenced today a secondary test to PURA's statutory obligation to evaluate the financial, managerial, and technical competence, or is it a test that is on par where they both have to be satisfied? If you could address that question and provide some examples, please.
Well, it's not in the statute. I mean, I think if you open General Statute 1643, you will not see a best interest of the customer's language in that statute. But we understand very much so that that's an important part of all the proceedings that you review and oversee. And we're not surprised to hear from the OCC and the Attorney General and other parties involved that someone has to come here and articulate what is the best interest for the customers. So while it's not in statute, we understand that it is a theme that runs throughout all your decisions, including prior change of control proceedings.
Thank you. When evaluating the financial, managerial, and technical competence, is it your position that we are evaluating the applicant's competence as it stands today or as it is post-transaction, as it would be post-transaction? Bless you.
God bless you. That's an interesting question. I think that when it comes to the end state of when the customers are going to continue to receive safe and reliable service, you're reviewing what the managerial status of that at that point in time will look like. So I think you have the discretion to review not only current RDOAW staff and those that will be overseeing the AWA when it is fully formed and fully realized, but I think you also have to take into account the Aquarion staff that will be coming along with the transaction and joining the AWA staff.
Thank you. And same question carried over to the public interest. Well, actually, let me do a foundational question. Do you view the public interest standard as the same or different than the best interest of customer standard? That's, I heard a slight distinction in your response to my first question.
No, I appreciate the question. Could you just say that one more time so I make sure I use the right phrases?
Sure. Do you see a difference between a public interest standard and best interest of the customer standard?
I think I was using those phrases as the same.
Interchangeably?
Yes.
Okay, thank you. So understanding you were using those interchangeably, my question is it Pura's role in this review of this transaction to evaluate the public interest standard post-transaction against a like a but-for standard, like but for this transaction, these benefits wouldn't accrue? Are we evaluating against a counterfactual? What is the evaluation parameters when undertaking that public interest analysis?
I certainly think you have to look at the public interest, assuming that transaction is closed, correct? That's what we're here for. I think you can take in other scenarios. And if the transaction doesn't close, for example, what happens to Aquarion's rates? And I think we've heard testimony that those rates are going to continue to rise. I understand that Aquarion has $200 million of capital right now in the field, producing results for customers, providing service used and useful to customers, but Aquarion is not earning a return on. That will have to change in Aquarion's next rate case, which I understand will be soon if this transaction does not close. So I think you can presume, and we all should presume, that rates are not going to still stay stagnant. Rates for Aquarion are going to rise over time. And when they do rise, they're going to include a return on investors' investment in their equity. It's going to include not tax-deductible bonds. It's going to include cost for WICA and for PFAS, and those are going to continue to put upward rate pressure on Aquarion's customers. And I think this commission should be very skeptical of comparisons that assume Aquarion's rates are not going to go up, because we know that that is not likely to occur.
Should it factor into Pura's analysis if this transaction were not to be culminated, whether Eversource or Aquarion would be seeking to sell to the next bidder? Is that part of the analysis?
That is not, I don't think there's any evidence of that before you. So I would say that's not properly in front of the commission today.
That's not one of the counterfactuals that you would articulate.
No, but I think we've heard specific arguments that this is not in the best interest of customers because Aquarion's rates are going to stay flat, and therefore customers are going to pay more in the future. That's been raised in this proceeding, and I think we provided evidence of why that's not accurate and should not be reviewed. But beyond that, we don't know what's going to happen to the future. If this transaction doesn't close, who knows what happens? Maybe Eversource doesn't sell it. Maybe it continues to operate it. Maybe it gets a rate case that allows it to continue to operate in the future. Those are some scenarios that we don't know, and we don't know what's going to happen.
Thank you. Nothing further. Thank you.
Thank you.
Attorney Ball.
I'm always leery of microphones because I feel like I don't need them. So thank you. Thank you for scheduling the oral argument. We appreciate the opportunity from our perspective, obviously representing, in my case, 4 municipalities, in Attorney McLeod's case, MetroCog. And I would like to touch on a number of issues. Before I do, I just want to say this particular application accomplished something that I really think would have been hard for me to believe coming into this hearing, because we live in this partisan world where you're either a Democrat or a Republican. We have big cities, we have small towns, and this application has done something that I think would be almost impossible to believe, which it is united every single municipality in opposition to the application. You saw the united opposition from my clients, they testified. You saw it from Attorney McLeod's clients, MetroCog. You saw Truck for a Lot submit testimony on behalf of all 25 municipalities in the WestCog and MetroCog regions and the city of Shelton. We're talking about hundreds of thousands of residents in the Aquarion service area, and every single municipality comprising those residents is opposed to this application. And you also obviously saw that unity of opposition from the outpouring of letters from elected officials, private residents, businesses, the Greater Bridgeport Regional Business Council. I mean, you're seeing it across a swath of different stakeholders. And to accomplish that kind of unity is quite amazing. So what I'd like to do is perhaps just focus on a few of the issues that have led to this public outcry of opposition, and why we all believe this is not in the public interest. And if I can, Attorney Hum began by sort of positing, well, there's 2 main issues. You got rates, people are justifiably concerned about rates, and you got governance, people are justifiably concerned about governance, and you heard the responses. I think I would suggest to you that the single biggest overarching concern that we have is the elimination of regulatory oversight. Okay, I think that permeates everything. Aquarion's a monopoly, and like any utility and any monopoly, the market cannot keep rates in check. It's an impossibility. Consumers don't have choices. They can't go to some other water company. If I'm in the Aquarion service area, Aquarion's providing my water. And that's precisely why we have governmental regulation. It's why we have you. Now, very briefly, the statutory comparison, I believe, is critical, because the new statute, which is undisputed that the applicants drafted, eliminates critical ratepayer protections. Today, when PURA's regulatory powers, and we brief this, are spelled out in great detail, right? Section 16-19E, subsection A, laundry list of factors that you have to consider in setting rates. And on page 3 of our brief, we set out all the factors the Connecticut Supreme Court reaffirmed that you consider: economics, public policies, accounting principles, fairness to all parties. Okay, lots and lots of different factors. The single biggest regulatory concept that permeates the current statutory framework is 16-19E, subsection A5, which says that rates must reflect prudent and efficient management of the franchise operation. The prudency requirement is the primary legal basis that protects ratepayers in our laws today. So a utility can't just make any capital expenditure that it chooses, can't pay its executives any amount that it chooses, can't make any business decision that it chooses, because ultimately we, the ratepayers, are the ones who end up paying for it. The law imposes much more than that on the utility. It requires that they demonstrate to you that their decisions are prudent and efficient. And most importantly, we don't let the utilities decide on their own whether they've met that very high standard. We have a carefully created statutory and regulatory framework that has an impartial arbiter overseeing all of those decisions, and it's you. It's PURA. So, Aquarion, Eversource, understandably, for their own reasons, they want to sell Aquarion. Aquarion, Eversource, and RWA came up with their own plan to get around all of this. And on the first day of the hearing, as I said, we learned that they drafted the enabling legislation. And respectfully, I don't think it's fair for them to now hide behind it. Hey, we're stuck with the legislation. It was their creation. This entire structure was their creation. And lo and behold, that very legislation eliminates the ratepayer protections and standards that exist in our current law. So I'll just focus on one of them, and I just mentioned it, which is the prudency requirement. As you know, in the most recent rate application by Aquarion, you concluded that you did not grant their application. Obviously, you evaluated it from the prudency and efficiency model and did not grant the rate increases that they were seeking. The Connecticut Supreme Court, about a week before the hearing started, actually affirmed your decision on Aquarion's appeal. And what the Supreme Court said is the prudence requirement counterbalances the monopolistic effects on ratepayers who do not have a choice about which company provides their utility service. The Supreme Court said a utility's only motivation to act prudently arises from the prospect that imprudent costs may be disallowed. The prudency requirement, as a matter of law, is essential to keeping rates in check. And eliminating the prudency requirement is not in the public interest. And there is no dispute that under the new statute is simply lower standards, and the prudency requirement is nowhere to be found. So the applicants draft a law that eliminates the heart of legal protections in Connecticut for ratepayers by eliminating the prudency requirement, but that's not enough. They go a step further because they want assurances of rate increases. So how to do that? They want or propose a structure that eliminates you. They create a structure that respectfully has a veneer of local control, but in fact is nothing of the sort. The governance structure that they created gives the power to determine rates to themselves. And if we're going to be honest about the purpose of the enabling legislation and this entire application, it has nothing to do with ratepayer interests. It has everything to do with stripping PURA of its powers. In the most recent rate case, you rejected Aquarion's proposed rate increases and you actually scaled them back. And it's no coincidence at the same time that you did that and that Aquarion appealed unsuccessfully, they embarked on this plan to lower the standards for rate approval and eliminate your regulatory oversight. And respectfully, eliminating PURA's regulatory oversight is not in the public interest. I would suggest it would be devastating to the public interest. Now, with respect to their reply, which is, well, wait a minute, it's not PURA. We have this wonderful independent AWA representative policy board that will be tasked with setting rates. It's a hollow argument for a couple of reasons. First of all, when you look at a rate application, you have all kinds of discretion to consider a multitude of factors. You decide what you want to give weight to, you balance all of that, and you come up with your own conclusion as to what the appropriate rates should be. The enabling legislation that the applicants drafted completely eliminates that modicum of discretion and balancing and actually ties the hands of the AWA Representative Policy Board. It eliminates their discretion. The language of Section 47 of their law, the enabling legislation, says the Aquarion Representative Policy Board shall approve such rates and charges unless it finds that the rates and charges will provide funds in excess of amounts required for purposes described in this section, or unless it finds that rates and charges will provide funds insufficient for such purposes. So you don't hear anything about prudency. The prudency requirement is eliminated. PURA is eliminated. And AWA Representative Policy Board, the supposed independent actor who will approve rates, has to vote up or down with no conditions under a statute that is premised on the fact that they shall approve the rate increases once AWA meets the lower standard. Now,
Attorney Ball, if I
yes.
could interrupt.
Yep.
I'm sure Attorney Hum or Attorney Canavan will rebut the, or will address this in their rebuttal, but I wonder if their response to that would be, well, by the time it gets to the up or down vote, there's no need for anything but an up or down vote because our process has been more transparent and we've seen it along the way and had input along the way. So how would you suggest that we take that into consideration?
I think the best way to analyze that is the difference between independence and not having independence. When a rate application is presented to you, there is no one in this room who would dispute that PURA is an independent arbiter, okay? The process that they created is an entirely internal process. They can call it transparent, but it is still entirely internal. The committees that comprise the supposed process that leads to a rate application are created by them. The ultimate recommendation as to a rate increase comes from the AWA board, and we'll get into the governance issue. I'll touch on it briefly, but as you know, it's controlled by the RWA. So now you have an entire management, the AWA board, the committees that report to the board and report to management, all vetting a predetermined outcome of rates that they want approved. And by the time it gets to the AWA Representative Policy Board, it's true, there's no discretion. They will follow what management wants. They will follow what the AWA board presents. And I don't have to guess because the RWA, as you know and as you heard, has a similar structure. And in the last 25 years, I think we heard that at no time ever has the RWA Representative Policy Board denied a proposed rate increase by the RWA board. It's entirely internal. There's no meaningful third-party oversight. It's, in my view, the fatal flaw of the entire structure. So we don't take any comfort from their internal processes. Frankly, I assume Aquarion has just as many internal processes today before they come to you to have an independent judge review it.
Thank you.
Now, the going along with the fact that the RWA Representative Policy Board has never denied a rate increase, the applicants are not hiding the fact that we are going to have massive rate increases. And as you saw in the briefs, the attachment 1 to OCC 42 lays it out in black and white. The rate increases are extraordinary. And I will just say, I represent towns. The ratepayers in my towns cannot afford to pay those increases. We have senior citizens, as you heard, as my client's testimony was clear, that can't afford to pay these rate increases. They are guaranteed, and I would suggest that is not in the public interest. Now,
Attorney
one of
Ball,
the other,
how
I'm
would
sorry,
you-
yes.
Excuse me, how would you address the, again, I think we heard in their opening arguments that there are going to be their position is that there are going to be rate increases regardless. So could you just address that?
I'd like to, thank you. You actually read my mind because that's where I was headed next. So the primary premise, I believe, for their economic argument as to the wonderful benefits of this transaction are that if the transaction doesn't go forward, there are going to be massive rate increases through Aquarion's application for rate increases to you. And so if anything, it's going to be cheaper. They call it a savings model. Well, their savings model is premised on a fallacy. The premise is that you are going to rubber stamp every rate increase application that they present to you. And that's the fundamental problem in their economic argument. It's speculative. Now, one of the comments, I think it was Attorney Canavan, said that towns are taking the position that rates are going to be flat. Nobody on our side has ever said that. We understand that there are good reasons for PURA to approve rate increases when they are prudent and efficient management. We understand that there are capital expenditures that are prudently determined that will lead to rate increases on occasion. We know that. No one has ever said that it's going to be flat. That's a false narrative. However, by no means can any of us assume that you will do something in the future that you have never done before, which is act as a rubber stamp on every single application that comes before you. And Aquarion knows that. I don't think that they truly believe you're going to approve a 28% rate increase next year. So it is an unfair argument to say that, well, rates are going to go up anyway, so you might as well approve this. I don't know what rates are going to happen, what will happen to rates in the future. But I do know that you have at least acted as a critical independent regulator overseeing rate applications. And I know that if rates increase, it's only because they're fully justified under the prudency requirement. And if we take that away, we have a problem. I am sure Aquarion would tell you that your decision in the most recent rate application to not increase their annual revenue requirement to 236 million as they asked for, and instead to reduce it to 195 million is something that they totally disagree with. If they could make the decision themselves, they would have approved it, as AWA would have. It is for them to stand before you and tell you that you would increase rates as they propose without the constraints that you are under our current laws, assumes that you lack the discretion of the model that they're setting up under the AWA Representative Policy Board. Their argument proves our point, which is it is precisely because of you and our existing statutes that we have the comfort of knowing that there is no guarantee of rates going up. And if rates do go up, it will only be done after careful independent review. It gets to the heart of why we think this is not in the public interest. I'll just touch on a couple other points. I know there's a number of speakers. Pilot payments, I think there's no dispute about the facts. The facts are that after this transaction would be approved, Aquarion or the AWA will no longer be paying property taxes. And instead, the statute that they drafted will provide for pilot payments. Now, they could have drafted the statute to say that pilot payments will mirror future property tax payments dollar for dollar. Could have drafted it that way. And that way, at least the municipalities would know that the millions of dollars of tax revenue that they depend on from Aquarion would not be taken away. They chose not to. Instead, they specifically state that pilot payments will not include real property improvements after the closing. So on day one, after the closing, if there's an improvement, say a building added to a pump station, without the closing, of course, that would be subject to property taxes. With the closing, it would not be included in pilot. That's a discrepancy. And that discrepancy grows, obviously, over time as there are more and more improvements on real property. This is not a small issue. Aquarion is one of the largest taxpayers in all of the towns that I represent and probably all the towns in the Aquarion region. My clients really depend on that tax revenue to provide municipal services they depend on. And to the extent the answer is, well, if AWA doesn't have to make those high property tax payments, their revenue requirements will go down. So indirectly, ratepayers will benefit. With all due respect, I do not think there is a single ratepayer in any of my towns who would like to see a reduction in the essential municipal services that are provided, like police departments and fire departments and schools and infrastructure, just so AWA can have reduced revenue requirements. My clients testified, they were clear about that. If their pilot is substituted for property taxes, there is going to be a direct negative impact on services that can be provided. And municipal budgets, as you know, are tight to begin with. That is not in the public interest. If I can shift to the governance structure, which will be the final point that I'll make, I think I can identify 3 problems for you to think about with the governance structure. First of all, it does nothing to promote local control in the Aquarion service area. Secondly, it's set up to create conflicts of interest without any solution. And third, consumers are going to lose any meaningful advocate. They'll lose any voice that they currently have with OCC. I'll touch briefly on each of those, if I may. On the issue of local control, the applicants attempt to rationalize the elimination of PURA with an argument that the AWA Representative Policy Board is comprised of people in the Aquarion service area, and therefore there's greater local control. But as touching on what I argued earlier, that governance structure does nothing of the sort, because the AWA board, not the representative policy, the board, it has 11 members, 6 of whom appointed by RWA outside of this area, and 5 by AWA. And the AWA board makes most decisions: compensation, capital expenditures under 3.5 million, acquisitions and investments in non-core businesses under 1.5 million, policy decisions, and most importantly, recommendations on rate increases to the AWA Representative Policy Board. So you've got this structure where the AWA board has a majority of RWA members who are not part of the communities where the water is being served. This was a law drafted by RWA. They drafted a law to give themselves a permanent majority in the Aquarion region. And even worse, it's an 11-member board. The 5 members appointed by the AWA Representative Policy Board can be removed by the RWA Representative Policy Board at will for any reason. So if they're not voting the way the RWA wants, they can be removed. There is a complete absence of control and an absence of local control, which in our view is not in the public interest. And finally, with respect to the AWA Representative Policy Board that, I touched on its absence of independence, but we have another problem. You're talking about a 60-member board comprised of lay people, not pure staff, not pure commissioners who are well-versed in analyzing rate applications. Those lay people are going to be 100% dependent on the recommendations of management and the recommendations of the AWA board, which is controlled by RWA. That dependence is real, and certainly explains why the RWA Representative Policy Board has never denied a rate increase by the RWA board. So to us, the structure is the opposite of local control, and certainly not in the public interest.
Attorney Ball, on the question of local control, if picking up on a line of questioning I had with Attorney Canavan, and in the absence of authority approval, in the absence of PURA approval, and to be specific, I know we have multiple authorities here. So in the absence of PURA approval of this acquisition, there's a existing control structure. I guess one way to view this would be, if the acquisition were to move forward, there could be an argument that there is enhanced local control over the status quo. How or should PURA take that into consideration?
Well, frankly, if the choice is between, first of all, I don't think there's local control enhanced by this transaction, because ultimately it's the RWA that has control of the AWA board. So that's my first response. I think if you were to ask any of the towns I represent, the municipalities, for whom local control, that's the goal, right? To protect the towns, they would all say they would far prefer the independence of PURA reviewing rate applications than the AWA itself. So can I stand here before you and tell you, well, this aspect of local control might be slightly greater than the other? I can't say that I can do that comparison, but I do know that one of the issues that the applicants have a burden of showing under the statute for you to approve this is that there is enhanced local control, and we would suggest this structure does the opposite. This gives control to the RWA.
Thank you. Getting to that test, I've heard a couple of them this morning: public interest, financial, managerial, technical competence, local control. Do you have a position on which of those, if any, are paramount to PURA's consideration of the acquisition before us?
I'm going to be very honest with you. It is something just as I think Attorney Canavan hadn't necessarily considered it. With all due respect, I don't think I have. I do think that we view this entire process as being a bit of a veneer. It is not promoting local control. And from our perspective, that is absolutely critical. So if you look at the structure today of PURA as an independent arbiter reviewing rate applications compared to an AWA representative policy board that's beholden to the RWA, I don't see any enhancement of local control. There are arguments that you read in the briefs. Attorney Miranda hit on the issue of managerial expertise and whether or not many of the actions taken by AWA in this docket prove an absence of it. I haven't balanced personally in my mind those factors. I am looking at an elimination of regulatory oversight as a devastating result, and that to me is tied with local control. If there was a meaningful third-party review, and it was comprised entirely of experts within our area, then I think that your question would be, spot on, and not that it isn't, but then it would be a completely different analysis. What I'm struggling with is there is no fostering of local control by virtue of this transaction. And there is a complete deprivation of regulatory oversight, which to us just defeats the public interest issue.
Thank you. A moment ago, you touched on Attorney Miranda's point in her brief, and I think that highlights my next question. In your remarks, I noticed that you didn't choose to focus on the test of whether the acquiring entity has technical, managerial, and financial competence to complete the acquisition. So am I to understand that you're adopting Attorney Miranda's position, or do you have a different view?
No, for sure, we are not ceding that point. We are not waiving that point. One of the ironies here is what I think I just heard from the applicant's counsel is, don't worry, everything's going to be the same. You're going to have the same management, same people. Well, if everything is going to be the same, then what is the need for RWA from the outside to come in and manage this process? There's a complete dichotomy there that is irreconcilable. If there's true managerial expertise within Aquarion, which I assume there is, and truly all of those folks will become part of AWA. If that is the case, then why is RWA suddenly in control of the board? To me, it's irreconcilable. On the issue of managerial control, I certainly will adopt Attorney Miranda's arguments as she spelled them out more articulately than I can now.
Thank you. This question is a bit out of order, but I noted in the earlier presentations from Attorney Hum and Attorney Canavan, and I apologize, I'm not sure who made the representation, but I thought I heard a representation that there were ongoing discussions about resolving some of these issues with conflict of interest in others. And to the extent I heard that correctly, is that something that the towns think that PURA should take into consideration in this process?
With all due respect to the comment, I do not think you should take it into consideration for multiple reasons. One, we're not aware of any such discussions. If those discussions are happening, they're not happening with my clients. And unless Attorney McLeod tells me otherwise, they're not happening with his. Are they having internal discussions? I assume they're constantly having internal discussions. They had months and months and months to work out the obvious conflicts of interest of a board with dual fiduciary duties and came before you without ever presenting that plan. It's, hey, Pura, once we get rid of you, just trust us. We'll take care of it after the fact. To me, that's not acceptable. They admit, the applicants admit that the AWA board members, who are the same as RWA, you've got this expanded board, 6 RWA members, 5 AWA members, with dual fiduciary duties to the RWA and AWA. And they state that as if that's a commonplace, as if that's something that happens. That's not something that happens. It's an impossibility. It's set up to create, it is literally set up to create conflicts of interest. Obviously, if I have a fiduciary duty to the Aquarion area, the decisions that I make for Aquarion might not be in the best interest of RWA. We can probably begin to identify some of those potential issues. But to say that, oh, we have every expectation that we're going to be in sync and have no conflicts in the future, I've never seen a board structure where you have board members with dual fiduciary duties. It is set up for failure.
If Pura were to trust trust them, you adopting your words that they were going to resolve the issues post-transaction. Does Pura retain the ability to unwind the merger if that does not come to fruition?
Not that I know of. And that gets to the heart of my concern. By the way, the conflicts of interest obviously is one of many, many issues. But once you are out of the picture, once this transaction is approved, I don't think you have regulatory oversight. I just don't. I'm not sure that you can undo it. They can make promises to all of us, and then they'll answer to themselves. It's a self-regulated structure.
Okay, so just to make sure I'm capturing your position correctly, and I will invite the applicants to address this in rebuttal, but if my very specific question is whether it's the conflict of interest or any other aspect of the application, any of the commitments, my position or my question is, what is your position on whether Pura can enforce any or all of those commitments post-transaction, and what is our remedy, if any?
I think my position is that the enabling legislation, which they drafted, does not afford you that power after this transaction is approved. It's in many ways now or never. The legislation was drafted to give you the final say as to whether this is in the public interest or not. If you vote thumbs up on this, you are out. I do not see anything in that legislation, and I've read it multiple times, that gives you a power to unwind after the fact, putting you in the very difficult position of having to make the decision now based on the record that's before you.
Thank you.
And if I have one last point, and I
Please.
know OCC will hit this, I'm sure better than I, but I just want to touch on the elimination of the role of OCC as a consumer advocate being replaced by the OCA. Respectfully, the argument that they are analogous is a false argument. The OCC, as you know, exists to put the interests of consumers first. They give us a voice. They speak truth to power. In the enabling legislation that the applicants drafted, OCC's role, like yours, would effectively be eliminated and replaced instead, according to them, by the Office of Consumer Affairs. The problem is the Office of Consumer Affairs, OCA, is not independent. It doesn't have that clear mandate and decades of experience arguing for the public. They are appointed by and can be removed by the RWA Representative Policy Board. That's not independence. And they can be removed for any reason. If I'm the one person, I'm the guy who's OCA, and I start pushing back on rate applications and the RWA doesn't like it, I can be gone like that for no reason. So that's not independence. And respectfully, we have seen through the history of RWA that it's not effective either. The testimony was that because of the yes-no vote structure, in the last 25 years, OCA has not even once objected to any rate application put before the RWA Representative Policy Board, not once. And in its history, it objected 3 times and was ignored all 3 times. Ignored is an overstatement. Its position was not adopted. Each rate increase was approved. The testimony was they don't hire independent consultants the way the OCC does. Worse than that, the testimony was that in the past, OCA has relied on the same consultants hired by RWA management to consider rate increases. That's not independence. They won't have the budget, the staff, the experience. It'll be one person who can be removed at will. So I'm going to conclude by just identifying, in summary, 3 critical pieces of this regulatory stool that currently exists that will be stripped if you approve this. The role of OCC, a true consumer advocate, will be eliminated. The prudency requirement, which the Supreme Court says is the only motivation for a utility to act prudently because of the prospect of imprudent costs being disallowed, stripped. And you, Pura, your role would be completely eliminated, which is really what I think is going on here. They want to get out from under your regulatory control, and the towns are urging you not to give up that power. We depend on you. The municipalities depend on Pura to be the independent regulator.
Thank you.
Thank you.
Attorney McLeod, please.
Thank you, Madam Chair. Good morning, Commissioner Gillette, Chair Gillette, my apologies, Commissioner Karen, Vice Chair Arconti when he returns. I am representing MetroCog today, as you know, and to avoid undue repetition, I will refer Pura to the arguments that have been made in MetroCog's brief and reply briefs, and along with arguments that have been made by other parties and interveners in opposition to the proposed transaction. As support for MetroCog's firm position that the application should be denied, I do rely on statements that have been made, for example, in the OCC brief, in the Attorney General's comments. All of these represent public opposition, along with the clients that I represent in the towns throughout the MetroCog and WestCog areas. They all represent opposition to the proposed transaction by the public. It may be that I failed to mention a few points that I briefed, and it would take a long time for me to cover them all, so I won't. But that doesn't mean I'm waiving anything that has been briefed. I would like to make the comment at the outset that I have challenged the managerial responsibility and suitability of RWA with AWA in the proposed structure. My comments do not go to RWA's managerial responsibility or suitability to run its own authority. They are only meant in conjunction with RWA's involvement in this particular proposed transaction. The point was made, I believe, by Attorney Hum that the authority structure will provide benefits to Aquarion customers that cannot be provided under an IOU model, investor-owned utility model. MetroCog really does not take a position on this at this point, but it may well be that there is an appropriate authority model. But this, due to RWA's involvement in the business of AWA, is not that model. And there is no other model that is before you, so I am left to address solely the proposed model of RWA involved on the board and in the executive suite of AWA. I believe that the applicants have a very unenviable task of proving that this transaction is in the public interest. I don't believe they can, because there are two sides basically in this proceeding: the applicants on the one hand and the public on the other. The public that the applicants propose to serve clearly doesn't want this transaction. The public has many reasons to oppose the transaction, which have been well briefed and will be and have been argued by other parties who oppose the transaction. These include pilot, the need and preference for Pura's expert and effective oversight in an upcoming period of necessary rate increases, and concerns regarding the authority model's rate making and use of revenues. With respect to use of revenues, I wasn't going to say this until I heard reference by Attorney Hum to it, but one example of that might be the RWA insistence that rate increases will be driven by capital expenditures and not by the assumption in the Aquarion Water Authority rates of an acquisition premium or fair value markup. It strikes me that if you have money available in your revenues and in your rates, that money doesn't necessarily have to be earmarked. Oh, this paid for the acquisition premium. If there were no acquisition premium, if those rates were not being used to pay off an acquisition premium or a markup, then that money could be used for capital expenditures and perhaps keep capital expenditures and rates to pay those a little bit lower than they otherwise would be. My comments, for the most part, will be limited to public interest questions arising from a flawed governance and board structure, which presents issues of outside control, disproportionate representation, and conflict of interest, particularly in my case, as those issues are affected by the political subdivision character of AWA and RWA. On the other hand, if you have questions about anything else I've briefed, of course, I would be happy to respond to those. I think one issue that needs to be tackled up front concerns the legislation. The applicants warn that it is not within PURA's purview to change the enabling legislation. To be clear, MetroCog is not asking the authority to change the enabling legislation. Instead, we point out that the enabling legislation subjects the proposed transaction to the authority's expert scrutiny to determine whether it passes the test of regulatory approval. Unless it passes that test, there is no transaction. In legislation tailor-made by the applicants for themselves, the applicants agree that the enabling legislation does not mandate the transaction, and further, that the authority retains its full power to disapprove the transaction and deny the application. Furthermore, MetroCog doesn't claim that Public Act 25-1 is invalid. However, its process has been criticized by legislators themselves, as you have seen in some of the letters that have been received in the public record. There were no public hearings. There was little debate, and the result is that there was an inadequate understanding of issues presented by the proposed transaction, including issues such as control of AWA by RWA. It's up to PURA to consider whether this is all in the public interest, and MetroCog, along with towns throughout the Aquarion service area, say emphatically that it is not. The application should be denied for reasons stated in our briefs, and particularly because it is not in the public interest.
Attorney
applicant-
McLeod, if I could interrupt, if PURA were to make a finding that the application is not in the public interest because we take issue with the governance structure, but the governance structure is specified in the legislation, how does PURA overcome a critique that we are attacking the underlying legislation rather than fulfilling our statutory mandate?
I think this was referred to you in the legislation itself for the full application of your powers to gauge whether it passes a change of control test. The change of control test obviously involves the elements of 1647, but it also includes determinations that the proposed transaction is in the public interest. I think you are free to look at any element of the transaction to determine whether the public interest is satisfied by that element or violated by it. In a sense, I think the legislature was asking you to vet the transaction to make sure it was okay. After all, this got rushed through. That is one proper interpretation I think you can make. You've been given your full power to review the transaction in accordance with what you always bring to your review of a transaction.
Thanks, please proceed.
Okay. I think actually you gave me the opportunity to get through my next paragraph, so I'll have to find my place in going forward. In terms of the legislature, the applicants have also seen fit to attack MetroCog and interveners for not having gone back to the legislature to seek changes to the proposed transaction. You've just heard from attorneys for the applicants that they are resistant to the idea of changing legislation. So that would be a battle we would have to fight. But I have two responses to the idea that we should have gone back to the legislature. First, RWA did meet with many towns and promised to consider their criticisms of the governance structure and board composition. The towns believed that there would be some consideration given to that. But RWA, as you know, has made no changes and today has indicated that it is not inclined to do so. Secondly, 25(1) Section 42 put this transaction in Pura's hands for review, as I mentioned. And Pura's assessment of whether the proposal is in the public interest has nothing to do with efforts by any party, whether it be the applicants or interveners, to seek legislative changes. This application is before you in its entirety for review as is. I think it's worth pointing out that regulatory review and approval was not required when the Metropolitan District Commission, the Southeastern Connecticut Water Authority, or RWA itself were established. This is a case in many ways of first impression, but the bottom line is whether or not it is in the public interest for one political subdivision of the state of Connecticut to control another public subdivision of the state without the latter's consent. I noticed that the applicants seem to skirt the issue of control in their remarks, but I think that is a key aspect of this entire proposal. Regarding the matter of control, the power to appoint a majority of the boards is the first obvious mathematical indication that 6 RWA representative board appointees can outvote 5 AWA appointed board members. So the RWA block can control the AWA board vote every time. Pura has recognized the likelihood that board appointees will vote as their appointing party wishes them to. And that is the concern presented here. I make reference to docket 180710, the application of the SJW group, which I have cited in my brief. Ownership is another excuse offered by RWA as to why they don't have control. They say because they are not owners, they don't control it. However, ownership is irrelevant to RWA control because RWA can appoint a permanent board majority without it. That's beyond argument. And it's reinforced by the fact that RWA's CEO must be AWA's CEO, and RWA's CFO was planned to be AWA's CFO. The board majority plus the executive influence gives RWA the power to direct the policies and management of AWA, directly or indirectly, alone or in conjunction with AWA. And therefore, that meets the definition of control under 1647A2 of the general statutes. And that also makes RWA a holding company of AWA.
I'm sorry, Attorney McLeod, can you make that point one more time? So you're suggesting that in the way the application is presented to us, that AWA is being structured as a holding company under RWA. Can you just make that point one more time, please?
I don't know that the application was presented that way, but that is the fallout when you look at the definition of a holding company under the under 1647A2. One entity becomes the holding company of another if it has the power to direct the management and policies of that latter entity.
And you're suggesting the relevance of that is what to Pyrrha's.
Well, I think it buttresses the argument that RWA controls AWA. Frankly, I don't know that it's necessary to call them a holding company. It does happen to fit the statutory definition of holding company. The key fact is that RWA controls the AWA board.
Thank you.
And the impact of that control is that if RWA controls AWA's board, that shifts control of a vital function from one political subdivision to another political subdivision situated elsewhere, despite universal public opposition that cannot, and that just cannot be in the public interest. In MetroCog's reply brief, it was noted that there is a further statutory indication that RWA will control AWA. As you know, the applicants have many times in this proceeding referred to AWA as an affiliate of RWA. By statutory definition, again, control is inherent in the affiliate relationship. Section 33-673A1 defines an affiliate as a person directly or indirectly controlling, controlled by, or under common control with another person. With respect to the RWA designed governance structure of its self-described AWA affiliate, RWA is certainly the controlling entity because there is no third party which controls both RWA and AWA, and it is RWA which has a majority of appointees on AWA's board and sits atop AWA's executive hierarchy. 33-673A1 also imports the definition of control from the Code of Federal Regulations. The site there is 17 CFR 240.12B2, which is virtually the same definition of control as is found in Section 1647A2. As defined, control, again, is the possession, direct or indirect, of the power to direct or cause the direction of management and policies of another person. That's the case here with RWA over AWA. Lest the applicants claim that 33-673A's definition of affiliate is inapplicable here because it's not in Title 16, I would note that when asked about potential conflict of interests, the applicants themselves offered a statute from that same area that I have just cited regarding affiliates. The applicants made reference to Section 33-756, which is in that same group from which I drew the definition of affiliate. RWA nevertheless argues that it has no control over the AWA board because the AWA Representative Policy Board, as an economic regulator, will make all economic decisions of consequence. I'm not going to repeat all of the arguments that Mr. Ball so ably made. He did it far more eloquently and thoroughly than I would. But the point remains that AWA's RPB is not in a position to exert any real influence over what happens at the lower level. I would also say that it would be no more true that AWA's RPB as an economic regulator controls Aquarion's board than it would be to say that PURA as a regulator controls Aquarion's board. You certainly have an influence on the outcome of rates and things like that. That is drawn into the supposed governance structure here. But we all know that actions speak louder than words. And there is no more eloquent refutation of the applicant's argument that the representative policy board would control the outcome of AWA board actions than the failure of the representative policy board, the RPB in RWA's case, over its entire 45-year history to reject even a single rate request forwarded to it by the RWA board. The RPB is hamstrung by the inability to modify rate requests and afraid to deny rate requests for fear of noncompliance with its generalized bond resolution. The same promises to be true of AWA RPB's acquiescence to rate increase requests and other proposals recommended to it by an RWA-controlled AWA board. As a side point, it is also noteworthy that structurally, the AWA board does not even report to the RPB. And it has, as Mr. Ball indicated, considerable leeway to take actions independent of decision-making by the AWA RPB. The conclusion by corporate dynamics, common sense, and statute is that RWA now controls AWA, and if this application is approved, will control RWA in the future. Excuse me, AWA in the future. I want to move next to the concept of public interest, and I want to take that in the context of political subdivisions, because I think that is a key element that this body has never had the opportunity to address before. The applicants basically have placed the tail of a tiger in your hands and proposed that you judge it by the same feline standards that have traditionally worked well for house cats. Just find under 1647, they say, that we can supply water. Just find under 1622 that any amount of projected savings meets the public interest test. And just find that because we're in state, that promotes local control. But it's not that simple. Because RWA and AWA are political subdivisions of the state, you're being asked to decide what constitutes the public interest in a far broader dimension than potential rate impacts. Consent, governance structure, board composition, and potential conflicts of interests are all necessary and appropriate elements of public interest under 1622 in a change of control scenario which places one political subdivision in control of another. Furthermore, where water supply switches from a regulated company under investor-owned utilities to a governmental function under a public authority, affected municipalities become major stakeholders. Where each authority is properly thought of as a political subdivision, the significance of issues confronting PURA becomes starkly clear. You're being asked to determine issues which may affect other political subdivisions in the state, including water authorities, transit authorities, port authorities, housing authorities, whatever. You're being asked, A, whether it is in the public interest for two political subdivisions serving two distinct areas to be under the control of one common board. B, whether it serves the public interest for one political subdivision to involve itself in the direction and management of another political subdivision without consent of affected municipalities within the latter political subdivision's geographic boundaries. C, you're being asked whether the public interest is served by a governance structure which permanently provides one political subdivision with a majority of appointees on another political subdivision's board of directors, and always, not temporarily, but always makes the CEO of one political subdivision the CEO of another political subdivision, even though the professed objective of such a structure is only transitional.
Attorney McLeod, is it your position that PURA is being asked to adjudge those issues, or is it more appropriate to think that the legislature has already adjudged that issue adjudicated that issue by passing legislation that allows that to be the case?
I think the legislature put this application before you in its entirety, and I believe that you can deem what is in the public interest on your own without violating in any way the structure that was set forth in the legislation itself. I don't think it's any different, for example, than it would be for you to find that there were no proposed savings or that there was some other traditional element of public interest which would call for denial of the application. You have your full power to review this application, and the legislature expects you to apply that power. That's my position.
Thank you.
The last thing I think that crops up here as a matter of public interest for you to decide is whether the public interest is served by giving residents of one political subdivision the opportunity through a majority board vote to dictate policies and make decisions affecting the residents of a different political subdivision without the latter's consent. In this context, it's highly relevant to a determination of public interest that the chief elected officials and legislators who are entrusted to assure that the public interest in towns throughout the Aquarion service area is met, uniformly oppose the transaction. They, rather than a regional water authority from a different region of the state, are in a better position to determine what is in the best interests of the public they serve, despite many meetings of the public they serve. And despite many meetings with town officials in the Aquarion service area, the applicants cannot identify a single town that supports the transaction. Public opposition is an undeniable indication that the transaction is not in the public interest. The transaction inspires a feeling of wrongness. From the viewpoint of affected towns in the Aquarion service area, the transaction is tantamount to a home invasion. Strangers have come to town from some smaller place elsewhere, admired the much larger facilities, and knocked uninvited on the door to say, "We're moving in forever and you're paying for it." The towns recognize these people as the same folks who came around many months ago with charts and models advertising savings and a fishy deal in which they would take a majority of seats at the dinner table, plan the menu, and put their cook in the kitchen, but somehow wouldn't control meals. They're the same folks who listened to complaints from the towns about such an arrangement, promised to consider them and get back, and then did nothing at all about changing the meal plan or seats at the table. The towns understandably don't trust the arrangement, and they want no home invasion. The issue of consent is cardinal here. Consent of stakeholders should be prerequisite to the establishment of political subdivisions, including public water authorities. The issue of consent is even more important here, where the transaction involves not just the creation of a public authority, but its unprecedented control by another authority. RWA's own creation required a 60% majority referendum vote of its towns. Comments and letters from towns in the Aquarion service area show that AWA could not have obtained such a majority for this transaction. Consent is the norm for other bodies politic in Connecticut as well. As noted in MetroCog's brief, political subdivisions such as towns cannot consolidate without a town vote to do so. Consent is key. In this particular case, although they met with various Aquarion towns, RWA never sought their consent for the transaction, and perhaps because they knew that they would not be able to obtain it. Because consent was not sought by the applicants nor demonstrated in any way by affected municipalities or residents, the applicants have not passed any public interest test in this regard. I'll now get to governance structure.
Attorney McLeod, before you do, if I can ask, although your last point may have already answered this. So on the issue of consent, my question was going to be which statutory test that is before PURA, what prong of which statutory test invokes consent? And I think you might have answered that last. You were fitting it into the public interest standard, but maybe you
I
can.
think it is comprised within the public interest standard and also by the prior example of RWA itself, where after a lot of debate and discussion within the affected towns, the decision was made to see whether this passed muster and gained approval of at least 60%, a supermajority of affected towns. And there are other statutory examples. I don't see it, to be sure, mentioned expressly in 1647, 1622, or 1611, but I do believe it is inherent in the concept of public interest. It is not so much that you have to obtain consent, but I think that the issue arises when you know the public is in extreme opposition to a proposal. There, the issue of consent becomes very critical.
Thank you.
We went through this proceeding hearing that AWA was being structured to mirror the governance structure of RWA, but RWA has finally admitted that its governance structure is not exactly what it is proposed for AWA. However, it tries to dismiss any difference, such as outside board control, on the basis that there were no other water authorities around to lend a helping hand when RWA was created in 1977. The authority should disregard this claim because it's flat out wrong. According to both Special Act 511 of 1929, which created the Metropolitan District Commission to provide water to Hartford and surrounding towns, and also Special Act 67-381, which created the Southeastern Connecticut Water Authority in 1967. As the record shows, it was another 10 years before RWA's enabling legislation was adopted in 1977. The assistance from another authority that RWA now claims is necessary for AWA is therefore something that was available to RWA when it was formed, but RWA found it unnecessary to pose that assistance from outside on itself. Neither MDC, the Southeastern Connecticut Water Authority, nor RWA have ever had outside assistance on their boards, nor have they had outside board control. In addition to the element of AWA board control by RWA and lack of consent, board problems also involve lack of proportional representation and unresolved potential conflicts of interest. Regarding proportionate disproportionate representation, the political subdivision context makes proportionate representation more important for water authorities than would be the case for investor-owned utilities, because proportional representation is a matter of good government. As noted in MetroCog's brief, a persuasive example of a proportionate representation requirement is provided in the political subdivision consolidation process set forth in Section 7-195 and following statutes in the general statutes with respect to consolidation of political subdivisions such as towns, boroughs, and political districts. I have said in my brief that is not directly applicable here, but it is of persuasive value. That whole process involved and required proportionate representation of the electoral, excuse me, uh, for the consolidation of one borough or town into another. Both towns had to be proportionately represented on the commission designed to study issues of consolidation. And then both towns or all towns involved in a proposed consolidation would have to vote to agree to join in the consolidation. None of that has been provided here. It has simply been by fiat that Aquarion basically has been told, hey, you're going to be an authority and you are going to be basically under the control of RWA. I think there is a belief that's still strong in this state that proportional representation is part of the fabric of American democracy. I'll go that far. Others would simply say it's the right thing to do. But it is not somehow part of RWA's board design for the expanded board. And it's clear that the applicants have never intended to do the right thing regarding proportionate representation. No math has been offered by them to explain why the RWA has apportioned board seats the way it has. The only math that jumps out to the observer, and the only math that really matters to RWA, is that there is one more RWA appointed seat than AWA. So RWA can control the board. Disproportionate board representation on a political subdivision board is not in the public interest, and it is unprecedented for a water authority, especially where the purpose is for a smaller entity to exert control over a larger one without consent. PURA should disregard RWA's hollow justifications for the board composition because they make no sense. RWA asserts that AWA needs RWA's experience to transition to the authority model. A board majority is not needed to impart knowledge. All of us have had classroom experience. We've all been in classes where there was one teacher from whom we learned. We didn't need a whole panoply of people to come in and impart knowledge to us. That very rudimentary example applies here too. You don't need a board majority of RWA appointees to help in the quote transition unquote to an authority model. One or two informed individuals should suffice. And I think there's even a question that you wouldn't necessarily get the knowledge you need or that is valuable from board members, because board members, at least of RWA and also of AWA, are very part-time workers. They attend a meeting a month. They have perhaps other things they do, but they don't necessarily have the utility knowledge, the rate-making knowledge, et cetera. They depend on staff, and it may be that staff is in a better position to provide that advice. And staff can also be hired rather than taking up a board spot. The last thing is that the applicants haven't shown that there aren't talented board candidates available in the Aquarion service area itself. They've just assumed that Aquarion would not be able to find somebody with appropriate experience to occupy a board seat without proof. Lastly, if the need is to provide transitional assistance, and I believe Attorney Hum emphasized this today, there is no explanation why a permanent RWA majority is necessary. None of the other water companies in the state found an outside board presence necessary, either on a temporary or a permanent basis. So that's a little bit of knowledge that is helpful to your consideration of whether or not this is in the public interest. The final point I would like to touch on is the conflict of interest. The expanded board presents complicated structural problems. Even if board seats were properly apportioned, in which case AWA would have 7 seats and RWA would have 4, the structural problems would remain. Because one set of people would serve as directors for 2 different authorities, there are inherent conflict of interest problems, which RWA disturbingly failed to recognize early on, and now cunningly proposes to resolve only if and after the transaction is approved. Let's revisit our hypothetical expanded board member, John Smith, whom you may recall from testimony. Mr. Smith faced the dilemma of acting in the best interests of RWA as an RWA board member, and also in the best interests of AWA as an AWA board member on a given proposal on which RWA and AWA interests conflict. There was never any answer provided to how Mr. Smith should respond, but such a conflict would theoretically impact all board members. And if they all did the right thing and recused themselves, there would be no board members, regardless of who sat and how many sat in particular board seats appointed by one authority or the other. They would all be impacted and they would all recuse themselves, and there would be no board left to make critical decisions. Even if, as was suggested in testimony, board members chose to prioritize their interests, that would, under the present setup, result in votes which AWA would likely lose every time. This is not an outcome, this is not a structure, this is not an arrangement that can possibly serve the public interest. The applicants shrug off these possibilities by suggesting that the relationship between the RWA board and the AWA board is standard practice, like the relationship between Eversource and Aquarion and its operating affiliates, or the relationship of a board of selectmen to town agencies and parties. These so-called examples are dreadfully off the mark, and they should be ignored. Eversource, Aquarion, and Aquarion's operating subsidiaries are affiliates which have their own boards. However, they all serve one set of shareholders, which owns Eversource, which in turn owns Aquarion and Aquarion's subsidiaries. The fiduciary duties of board members of Eversource, Aquarion, and Aquarion's subsidiaries are all owed to that single set of shareholders, Eversource's owners. In the Board of Selectmen situation, each select person serves on a single board, serving a single municipality and that municipality's residents. The first selectman of Ridgefield does not also sit on the Board of Selectmen of Westport, nor as a non-resident of Westport would he be allowed to. The expanded board, on the other hand, is the reverse of the foregoing situations. A single group of board members serves 2 different entities, RWA and AWA, answerable to 2 different customer bases and 2 different ownership publics. Unlike the first selectman of Richfield, who can't also be a selectman of another town, John Smith would basically be on one board serving 2 different publics, 2 different masters. The conflict of interest problems in the combined board structure should have been recognized long ago, and it is disturbing in terms of management responsibility that they weren't. It is also disturbing that the applicants offer to adopt the conflict of interest policy well after the application is approved because, as I believe is appreciated by most, the applicants would at that time be beyond PURA's command. You asked Mr. Ball, I think, this question. I would agree with Mr. Ball that the legislation is clear that if you approve, you no longer have jurisdiction over the applicants to enforce any conditions that you might attach to ameliorate some of the less desirable aspects of the transaction. So the result is that any commitment for a conflict of interest policy would be unenforceable. Unfortunately, Pura is not being asked whether a lesser degree of intrusion, either in terms of board composition or limited duration, might have been acceptable, because that's not what's proposed, and Pura would have no jurisdiction to enforce the conditions as stated that it might deem appropriate. In short, the transaction arouses a strong sense of violation as far as the towns are concerned, a feeling of forced submission, a permanent subjugation to unwanted control by another without consent, and a disrespect of proportion. Metrocog and towns throughout the Aquarion area strenuously resist the overtures of RWA. And they would find any transaction representing such a combination of shortcomings to be totally incompatible with the public interest. The applicants have fallen far short of their burden of proving that the application is in the public interest, and Metrocog respectfully requests that the application be denied. Thank you very much for your time and consideration.
Thank you. Any further questions? All right, thank you.
Thank you.
OCC, please.
Morning. Allison McCorney for the Office of Consumer Counsel. Firstly, I just wanted to quickly circle back to a question that Chair Gillette had asked of Attorney Canavan regarding the requirement that any applicant seeking a transfer of ownership of a public service company has the burden to prove that the transaction's in the public interest. I understood the response to be that such a requirement is not in statute. We would respectfully point the authority to Connecticut General Statute 1622, which does indeed require the applicants to prove such a transaction is in the public interest. So while it may not be in the acquisition statute, it is statutorily required nonetheless. Turning to the application, the applicants claim that this acquisition would save ratepayers money. OCC did not see that assumption borne out either through the application or within testimony. The applicant's assumption that the investor-owned utility would cost more in the coming years relies on the assumption that Aquarion would be subject to quote-unquote perfect rate making, and that the authority would grant Aquarion 6 base revenue requirement rate increases over the next 10 years. The model presented ignores the unlikelihood of such frequent increases based on historical precedent, as Aquarion has only sought 3 rate increases in the last 15 years. The applicants claim that avoided cost of nearly $65 million by avoiding a rate base increase is hypothetical and should not be relied upon as an accurate benefit to current Aquarion ratepayers. Despite OCC's best efforts to earnestly understand whether the AWA model is financially superior to the AWC model, we remain unconvinced that the record even provides enough detail to appropriately make that determination. Turning to the Office of Consumer Affairs, OCC outlined several concerns with the relative lack of resources and staffing, and I would point you to our brief for a more thorough explanation of our concerns. This transaction would significantly increase the amount of customers for which the OCC is advocating, and there is little indication that there will be additional resources or staffing to accommodate that. OCC does appreciate the newly proposed commitment by the applicants in their reply brief, stating that the AWA Representative Policy Board and the RWA Representative Policy Board would each have an OCA. While that addition does not alleviate all our concerns surrounding the necessary consumer advocacy regarding this transaction, it does help, and the OCC does appreciate that the applicants are taking what the parties have discussed during the hearings and making changes based on those discussions. However, as laudable as this and other commitments made by the applicants may be, another major concern our office has is whether any commitment is ultimately enforceable. Without Pura's oversight, once this transaction is approved, the applicants haven't proposed any mechanism to ensure these commitments are met, nor are there any consequences if they are not. As I believe Attorney Hom mentioned and Attorney McLeod just touched on, the applicants are offering to submit to OCC and the Attorney General's office a conflict of interest policy applicable to the AWA and RWA authority boards and representative policy boards. Again, a seemingly worthy commitment, but offering such a policy to the OCC when OCC is no longer the consumer advocate and PURA no longer has regulatory oversight is little more than a gesture, even if a well-intentioned one. If PURA is inclined to grant this transaction, OCC recommends that any commitments made by the applicants must include some sort of enforceability mechanism. Also, as discussed in our brief,
Attorney McCorney, can I touch on that? Does the OCC have any recommendations as to what an enforceability mechanism would be? Maybe Attorney McLeod and Attorney Ball could touch on this when we go back through rebuttal, but I understood their positions to be that the legislation stripped PURA of the ability to be in a position to enforce the commitments post-transaction. So I'm struggling to think what we might put in there that would overcome that legislative intent.
right, I appreciate that concern. I think that it's up to the applicants. Overall, OCC's recommendation for this transaction is that in its current form, it's not adequate to serve the public interest, and the applicants need to work among themselves and with all the interested parties to understand the concerns and address them in a new application to present before PURA. So while I don't have any specific, I don't think this is exactly the right forum to present any specific recommendations to that. I think that's just an example of one of the areas that the applicants need to further consider in a new application to PURA for this transaction to go through in a future proceeding.
Thank you. So I saw that point and I believe it was your brief. Wasn't sure how to balance that point, but I take it that the OCC's overarching recommendation here is relying on the filing of a new application. Let me formulate this into a question. How should PURA think about the OCC's recommendation that the applicants file a new application versus like what we have in the record before us? Was it, I mean, that was the OCC's remedy? Was that we should reject this and they can file a new one, or?
Yes, it's the office's position that this application in its current form is not adequate. It does not give us enough information. It does not prove that this transaction is within the public interest. If the applicants would like to submit a new application, the OCC is more than willing to have discussions about what we think needs to be present in that application, but we're not satisfied that the application as it currently stands is adequate to say that this is in the public interest of current Aquarion ratepayers.
Okay, thank you.
Turning to the next point, also as discussed in our brief, the Aquarion Water Company and the Torrington Water Company currently hold balances of excess accumulated deferred income tax, which will not be due to the federal government as a result of the Tax Cuts and Jobs Act. We understand the position in the reply brief to be that those credits will continue to flow back to customers post-transaction by virtue of the fact that there is no immediate plan to adjust current Aquarion rates. Our concern is that this position doesn't align with our understanding of some of the testimony at the hearing, which seemed to convey that there are no guarantees about what will happen to the ADIC credits under the AWA model. And again, it's unclear at this time how any such guarantees could even be enforceable. These tax credits are due back to ratepayers, and before this transaction is closed, again, if the authority is inclined to grant it, OCC would request that the authority would require the remaining unamortized amounts of these deferred taxes be returned to both Aquarion and Torrington Water Company customers. I do believe if the authority would allow that Consumer Counsel Coleman has some additional comments today regarding our position. Thank you.
Good morning to the authority. Thanks very much for your time today to hear all of the arguments before you. I did just want to take a minute to respond to some of the arguments we've already heard here today, both from the applicants as well as from Attorney Ball and Attorney McLeod on behalf of the towns that are uniformly against this proceeding. I think at a high level, when I listened to the arguments presented today and after reading the briefs and the reply briefs, the state of play we're in is incredibly premature to approve the application before you. There have been arguments, both in the applicant's reply briefs and today, that we would argue contradict record evidence that we heard throughout the hearing. There's new, financial impact arguments we've heard. There are belated commitments made in the briefs here today, but that are not sworn to, or as to the point about enforceability just now, are not meaningfully enforceable. Some of the comments I've heard from the applicant's attorneys today included comments like, we're open to enhancing commitments. This is still in progress. A response to one of the questions received the commentary that will recognizing this requires further development. So these are statements that are being made in the context of a very significant application for change of control that's going to significantly impact customers across the state, current Aquarion customers. And as the representatives of those current Aquarion customers, we have significant concerns with the state of the application and the evidence before you, and would submit that clearly the applicants have not met their burden with the application that is currently before you. Chair Gillette, you just asked my colleague about sort of what OCC's position is with respect to the fact that the application isn't complete, and we've suggested that they refile. Certainly, it's within the authority's discretion. Next steps in this proceeding are issuing the draft decision. The applicants certainly have the ability to seek other forms of relief, including extending timelines or refiling. We've suggested starting over, but there are certainly other avenues, including substantiating the record. We've also talked or heard today about the significant concerns about governance. And we, recognize that some of the governance concerns raised today in briefing are due to the enabling legislation, and as has been discussed, are not in the hands of the authority to change. Commissioner Karen suggested whether there are opportunities for making necessary changes. And I would note that there's been substantial reporting that there is going to be a special session in October, which could provide RWA and AWA an ability to conduct that outreach that they're representing is important to towns and to other stakeholders like ourselves and the OAG, to address some of those concerns in the legislative forum as well. My point in raising all of these ideas is not to complicate things further, but to say that that the authority has been put sort of in a very difficult position, which has been presented as a black and white approve or deny and determine, whether or not this acquisition is in the public interest. But there are still ample pathways, different pathways, both the applicants and the authority could take that would help resolve all of our concerns and ensure that the proposed new RWA, AWA framework is not rejected with prejudice without considering and exploring these other options. I do want to emphasize and remind the authority, as I'm sure you're aware, and as is noted in our brief, that it's not uncommon for the authority to reject change of control applications in the first instance. In fact, the authority has done that several times. We've cited to a couple in our brief, the Iberdrola acquisition of UI, SJW's acquisition of Connecticut Water. In both of those cases, the authority said, you haven't done a good enough job to ensure that this is in the public interest, that customers are protected, and go back and try again. And we'd respectfully submit that that is the appropriate path here, where there are so many questions still left about what the impact on current Aquarion customers would be, as well as outstanding commitments that the companies have stated they may be willing to make, but that have not yet been fully developed. We would submit that we agree with the concerns articulated by the town attorneys today, and certainly submit that the applicants have not met their burden of proof, and we'd ask that the authority not approve the application before it today. So, thank you.
Questions? Thank you. Attorney McCormick, please.
Good morning, Chairman Gillette, Vice Chair Conti, and Commissioner Karen. To start, this is a complex situation. Aquarion is a well-run utility which provides safe, reliable service to customers. On its face, transitioning an investor-owned utility to a nonprofit public water system model sounded positive because the dynamics that can create upward rate pressures are removed where the utility doesn't require equity capital and does not incur tax expense. However, as interrogatories were answered and the hearings were held, our office developed serious concerns over this transaction. We appreciate the work of Aquarion and the RWA to provide safe, reliable water to customers. However, as highlighted in General Statute Section 1622 and in previous PURA decisions, the PURA must also find that the transaction is in the public interest. I echo the comments of the OCC and the towns, and I'd like to focus on 3 areas that demonstrate this transaction is not in the public interest. First, this transaction is too expensive for consumers. Second, the loss of PURA oversight and a lack of a meaningful consumer advocate structure takes away critical protections for consumers. And third, the towns are unified against this transaction. First, this transaction is too expensive for consumers. As has been briefed in this proceeding, the cost of this acquisition, nearly $6 billion in debt service for costs of the acquisition alone, plus other costs associated with remediation, capital projects, and operations, is far too much for customers to shoulder. To put this in perspective, the nearly $6 billion to pay off this debt is more than 30 times Aquarion's entire annual revenue requirement of $195.658 million. These staggering numbers promise unaffordable year-over-year rate increases for Aquarion customers that are clearly not in the public interest. These unaffordable year-over-year increases are spelled out by the applicants, and worse, are essentially guaranteed rate increases with the structure the applicants have put in place. As has been thoroughly briefed, the RWA has never rejected a rate increase application, even when their consumer advocate has rejected a rate application proposal. Rate applications under this structure must be approved or rejected in their entirety, not allowing for line item modifications. As answered in the hearings, PFAS costs will not have a separate rate approval process, but instead will be part of the normal rate application request. This is problematic because critical cost increases will be in the same application as other costs, but the whole application, including both, must be either fully approved or denied. We fear this structure weakens the consumer advocate's ability to effectively replicate what the PURA in our current structure does. This brings me to my second point. No PURA oversight and the lack of a meaningful consumer advocate structure takes away critical protections for consumers. This application proposes taking away all oversight and transparency from the largest water company in the state. The company's solution is a consumer advocate who is fully dependent on the very company it has to critique. In light of our brief and others filed on August 22nd, the companies updated in their reply brief that there will be a separate Office of Consumer Affairs for the RWA and the AWA. This does not resolve our concerns. The low hours worked per week still exist. The appointment, removal, and approval process of the advocate remains unchanged. The advocate does not hire experts for rate cases, even though the budget allows for it, to ensure that consumers are getting the best possible deal. The advocate does not quantify or report cost savings to customers that the advocate is responsible for. The consumer advocate is still bound by the structure of approving or rejecting the application in full and cannot offer specific line item adjustments in the memo. Even if the consumer advocate does reject a rate application, the board is under no obligation to also reject that very same application. In fact, the previous consumer advocate has rejected rate applications 3 times in the past. However, the RWA disregarded those criticisms and nonetheless approved those rate applications without modification. This is an especially sensitive time for customers with the cost to remediate PFAS and lead on the rise. The PURA has a proven track record of thorough regulation and oversight for customers. Further, the consumer advocate, as proposed, is in no way comparable to the services that the OCC, EOE, and the OAG provide in rate proceedings. That brings me to my last point. The towns are unified in their opposition to this transaction. The towns have come in incredibly organized, represented by council, and have made their voices heard. They do not want this, for the reasons we have briefed, in addition to the others voiced at the hearings. We have the public interest. The towns and the municipalities are the proxy for the public here. We shouldn't have to dance around these issues. The public interest involves a degree of consent to be transitioned. As Attorney McLeod said, the issue of consent should be paramount and dispositive. This is not an emergency. The customers are getting the service they need under your supervision of the PURA. Given the solid opposition of the towns that should be dispositive today, this deal should be reworked with participation and acknowledgement of the towns. And that's why the legislation was put in place for you to consider that and to approve the transaction or deny the transaction. The proposed transaction at this price, with these lacking protections for consumers and unified opposition from the towns, is something the Attorney General cannot support. For the foregoing reasons, as well as the issues briefed by the other parties, the Attorney General urges the PURA to reject this application. If you have any questions, I'd be happy to answer them.
I think the only question that I have is the question I posed earlier about the enforceability of commitments post-merger and whether the Attorney General has a position on that. Specifically, PURA's ability to enforce commitments post-merger.
We think that that is one of the very reasons that the PURA needs to reject this application and to put forward a new application, because that's a concern for our office.
Thank you. I don't think there are any further questions. We're going to break until 11:15. At 11:15, we will resume with rebuttals. We'll allow for brief rebuttals from all the parties and interveners. Okay, we're gonna go back on the record in 250403 for a rebuttal round, and I'll ask everyone to be cognizant of the time and concise in your remarks. So Attorney, please rebuttal.
Thank you, and thank you for the opportunity for rebuttal. We will be as concise as possible in our remarks, and I'll start at the outset that many of the arguments that we heard today are addressed in either our initial brief or in the reply brief. So to the extent I don't address an argument in rebuttal today as part of the oral argument, we're certainly not waiving it. We would just refer to the briefing. So I think one thing to mention right off the outset is that we heard a lot about every single municipality is against this. What I do want to point out is that it's not every single municipality. There's only 25 municipalities out of a potential 60 who are involved as part of this proceeding. So that's less than a majority. So I do want to dispel right up front the idea that every single municipality is opposed to this.
Attorney Hum, is there evidence in the record that suggests that the remaining municipalities are in favor of it?
No evidence that I'm aware of in the record, nor is there a requirement for the municipalities to either indicate whether they're in favor of it or opposed to it.
Do you have a position on arguments that we heard earlier today with respect to consent being a factor that the authority should take into account in a public interest evaluation?
Sure. So that was something under the RWA legislation, under the RWA establishment that was created by their enabling legislation. That's not something that was part of this enabling legislation. To require municipality consent would be a change to the enabling legislation that was already set forth and that the parties have been working under as part of this transaction.
Okay, the enabling legislation, I take it, by that you're referring to the vote that was required in the RWA service territory?
Yes, correct.
Okay, so your position is because the enabling legislation is silent on whether there's consent needed from the AWA service territory, that PURA cannot take that issue into consideration?
I don't think it would necessarily meet the statutory standard without any specifics. The statutory standard, I'm not going to get into the great details about it, but managerial, financial, and technological capabilities, the ability to operate a safe and reliable system, and the public interest. The public interest is a consideration here. There's nothing specific with respect to requiring a municipality consent. I think what I would offer is that when we talk about public interest, it's public interest of the customers. And we didn't hear very many comments, particularly from the towns, about public interest of the customers. And that's where the focus should be, on the public interest. And that's what we've been trying to show when we've talked about things like savings and the lower rates based on the setup.
Thank you.
So I'll say I mentioned the enabling legislation as crafted. It does support the authority model. That's the way that it was set up. That's the way that it was put forth. And as I mentioned earlier, that's the way that the credit ratings and the bonding rating, that's how they were all implemented based on their review of the enabling legislation that was approved by the legislature. So clearly something at the time that the legislature had approved. Can it be amended in the future? Of course, anything could be amended in the future, but that's not what's before us today. What's before us today is the enabling legislature as it stands, as approved, as set forth with the authority model as set up. Commissioner Karen asked a question earlier, and I want to revisit that a little bit with respect to when I talked about the transition period and things of that nature. So again, the reason that they need the transition period is to ensure that if the transaction is approved, that it's successful for customers. After that transition period, after that transition period, and again, I've already gotten to the reasons why the authority model is set up as it is. After that transition period, that's when you can potentially see some changes in the voting structure. For example, those are some things, and I'm going to touch on this in just a minute, but those are some things where details can be worked out. And what I mean by that is there's still time. There's still time even within this proceeding. And I'd like to point the authority to Connecticut General Laws 16-19JJ. And that's what provides an opportunity for PURA to entertain ADR to resolve proceedings. And that's what also provides an opportunity to file proposed resolutions to put before PURA. So when we talk about enhancing commitments and when we talk about things that we're still looking at, we're not just saying, oh yeah, this is what we're doing, don't worry about it. We're saying that we're working towards potentially proposing something within the deadlines that are set forth by 16-19JJ.
Attorney Hum, how does that, maybe I'm skipping forward to something that you would plan to address later, but I'm still not sure how 1619JJ resolves the discussions that I was having with various parties with respect to the enforceability of commitments. Presumably, if you put something before I'll try to use PURA instead of the authority. Presumably, if you put something in front of PURA under 1619JJ, it as a settlement or other partial or otherwise, what is it about the settlement or commitments or anything that survives PURA's jurisdiction here in terms of the enforceability of those commitments post-acquisition?
So I'll say a couple of things there, and thank you. And I think the applicants hear those questions and they hear the questions from PURA with respect to the enforceability. I will say that is something that we're working on. We get it, we're working on it. We hope to have a proposal by what we can submit within 16-19JJ. I believe the deadline to submit based on the timeframe set forth in the deadline is October 1st. It needs to be filed 3 weeks before the PURA proposed decision comes out. So that's the time frame with respect to any resolutions or enhancing these commitments or addressing things like the enforceability that we are actively working towards.
I think that's, a deadline. It's was it a ceiling, not a floor? So, I mean, there isn't, am I to understand you correctly, there's nothing before PURA today that addresses the enforceability of commitments or the enforceability of a settlement. There's no remedies, there's no time limit on enforcement. There's nothing that PURA has in front of us today that would address this concern.
Nothing specific other than any legal remedies that any party potentially could have under law under any circumstances. The other thing I will say is, again, that's how the enabling legislation was set up. So that's the framework that we're dealing with. And the way that this potential transaction is set up is as a sale to a non-investor owned utility, and not a utility that's not regulated by PURA.
Does that counsel you to think, I mean, is it then the parties, your client's position that this is, the legislative intent is that this is supposed to be an up or down transaction, that it passes or fails on its merits alone, absent supplemental commitments or conditions?
I think it would depend on what the commitments are. I don't think it's a blanket black and white up or down. I think, as we mentioned, I mentioned in our opening remarks and we mentioned in our briefs, we do have commitments that have been put forth. They've been in the initial, they were actually in a discovery response earlier in the proceeding. They were in our initial brief, and they were even enhanced in the reply brief. So there are certain commitments that can occur. It depends on what the particular commitment is.
Mhm. Thank you. Sorry, I'll get more to the point. I'm trying to tease out the reference that you made, two responses back to, well, this is the legislation. So if the legislature is presumed to have known, I forget the exact statutory construction language, but you know what I'm talking about. It's the legislature is presumed to have known what it was doing at the time it passed it in light of the body of laws or whatever the exact language is there. So if they were presumed to know that they were passing something that cut off Pura's jurisdiction at the time of Pura's final decision in this matter, uh, how does that square with my immediately preceding question about, well, wouldn't that then counsel that Pura's to make an up or down decision on this absent commitments that we don't have the ability to enforce if that's how you construe the legislation?
So to answer that question directly, in theory, it could. But that's why we're working on the commitments and enhanced commitments, because what we could do is we could just say, like, nope, we're not going to do anything. We're not going to propose anything additional. You need to make an up and down vote based on what's before you and based on the statute. And that's why through those iterations, we have identified those additional commitments and those enhanced commitments that the parties are willing to do. Are there more? Potentially, yes. And that's what we're hoping to work on in the next couple of weeks.
Thank you. And then before I took you down this pathway, you were briefly speaking about the transition period. And my specific question on the transition period is that if you could remind me whether there's anything in the record regarding the length of the transition period, or what I don't, as we say here, I don't recall it being the subject of much discussion during the hearing process. That could be my recollection. So I'm hoping that you can point me to whether there's anything in the record or briefs or elsewhere that speak to the length of the transition period. What would govern it? Does it require legislative action to end it? I'm just, I was a little unclear about, it seemed like we were starting to use transition period as a defined term, and I was hoping you could illuminate me about where I could go in the record about that.
Thank you, and I'm happy to do that. And I also recognize I hadn't fully answered Commissioner Karen's question, so I'm glad to kind of wrap this up together and provide a response and then answer any additional questions from there. So we've talked about the purpose of the enabling legislation set forth the authority model. The authority model is what derived the credit ratings and the financial information that governs this transaction that will govern AWA going forward. The reason that that's important is the transition period is something that would need to encompass two budget cycles, two bonding cycles, to kind of go through that process where, again, the credit ratings I've set. So it's going to go through the financing process that I talked about in my initial remarks. If it can go through two of those budget processes, then there are opportunities for changes. There are opportunities to change the weighting of the votings and to ensure that there's an AWA majority of the votes.
Can, do we receive testimony to that? I'm sorry. This is, it feels like new information to me, but it could just, again, it could be very much my recollection. So and I can give you a moment, we can circle back around, but I just want to be able to go back and lay my hands on something that substantiates what you just said so I can read more about it.
May I have just a moment to confer?
Absolutely.
Thank you. Thank you for the opportunity. The way that it would work is not specifically in the record. What's in the record is what I mentioned about the credit ratings and the financing aspect. What's in the record is the opportunity for additional committees for the AWA RPB. What this is a commitment that the parties that the applicants are willing to make in order to ensure a successful transaction that addresses some of the concerns that have been raised.
Thank you. I appreciate that. I have another question, but we haven't quite gotten there yet. So please continue.
Apologies, just one moment. Thank you. So if I can further elaborate on that one, with respect to kind of what I mean and how that would work, is once the AWA Special Transition Committee determines that the steady state criteria are met, and that's what I was talking about with, it would need the two bonding cycles, then the voting of the RWA and the AWA boards could be bifurcated such that only the board members appointed by the AWA RPB will vote on the AWA operating and capital budgets, and the decision to submit AWA rate applications to the AWA RPB for consideration. The RWA RPB appointed members would not vote on these matters.
Okay, so the explanation you just offered is not in the record, but the committees that you just, what is in the record? The fact that there are committees, but the explanation you just offered in the last couple of minutes is not in the record?
In terms of the AWA RPB and its committees, the committees are not limited to the statutorily defined committees, which is the Finance Committee, the Consumer Affairs Committee, and the Land Use Committee. There's opportunity under the enabling legislation for the additional committees. So all that's in the record. What I'm telling to you in terms of the specifics and how this would work, this specific information is not on the record, but it's something that the joint applicants are willing to commit to.
Thank you.
Another item that I want to touch on is the potential to dismiss this particular application without prejudice and to refile it. I think the examples that were cited from prior PURA decisions, I think the circumstances were different because they both involved out-of-state entities. The commitments that ended up coming about as a result of the rejection of those applications and the refiling were to address issues of those applicants being out of state and not having enough local control. And I think the facts of this particular proceeding that are in the record that have been identified throughout the briefing, et cetera, they emphasize the fact that it's an in-state Connecticut public corporation and there's essentially unmatched local control, and we do stand by that.
Thank you. How do you respond to the town's rebuttal to that, which I understood to be, well, it's not local control because it's not our town's local control. It's so it's, I don't know. I guess the point is it's no better than local control from a foreign or out of state entity. So can you address that point, please?
So I think to address that point, I think you ended the question by talking about a foreign or out-of-state entity. Under no circumstances are there any out-of-state entities that would be involved as part of the transaction post-closing. I talked about the enabling legislation and the way that it was set up, so I'm not going to repeat what I've said there. And I've talked about the Special Transition Committee to address that particular issue. Do you have any further questions?
Yes, I apologize. Maybe I just didn't phrase the question well, but I'm trying to fully flesh out the point of local control. From where I'm sitting, it seems like we have two divergent opinions on whether the acquisition would result in local control. Two different opinions with the same set of facts, and I'm trying to make sure I understand your client's viewpoint on why the facts support local control versus what we heard from the towns in the first round, which same set of facts. And my understanding is they're suggesting that that does not result in local control. So if there's anything else that you wanted to say as to why you think the facts do support a finding of local control, given the governance structure that the legislation calls for.
So in addition to relying on the enabling legislation and in addition to what I mentioned about the Special Transition Committee, um, I'll also refer you to what we talked about in our opening remarks with respect to the role of the AWA RPB. In terms of local control, they have the economic decision-making authority. So they have essentially all economic decision-making authority for the AWA and the Aquarion towns going forward. When we talk about the AWA board and what their role is, they do have an independent role specific to the AWA. When they're reviewing AWA matters, we've talked about throughout the case, we've talked about the fiduciary duty that they have to the AWA communities. So when they're acting within their role as the AWA board members, they have that duty to the AWA communities. There was discussion about the decision-making and rate-setting process not being independent. And I think I'd argue that it is. And I think the local control emphasizes the independence of that rate-setting process because it's not a rubber stamp just by the RWA in their circumstances or the AWA in their circumstances. It's something that's reviewed by the towns, by the municipalities who are involved. So it is independent with respect to how those rates are set.
Thank you. Sorry, thank you. Please proceed.
May I have one more moment to confer? Thank you. Thank you. I think we'll rely on our briefing and the arguments that we've made today. If there are additional questions, we are here and we're happy to come up again. And I should say, are there additional questions before I leave?
Funny you should say that.
Okay.
So you were talking earlier about commitments of Christmas is yet to come. And what I've looked at the updated commitments in the reply brief don't seem to address any of the concerns that have been brought up in the briefs throughout the hearings and in today's orals. So are you saying that between now and October 1st, there may very well be new commitments? I think you mentioned a change in the AWA board makeup from a majority of AWA towns. Are those the kind of things you're talking about that we may see before October 1st?
Yes, those are the kinds of things that we're talking about that we are still working on. And apologies for not having an answer on them today, but we are still working on those. We're actively working on them within this proceeding. And that's why I referred to 16-19JJ, with the opportunity to address those and to enhance the commitments. I think I'd argue if there are any additional concerns that you do not think are raised by the commitments that are in the brief and the reply brief, we're happy to address those as well.
Okay. Attorney Ball, when he made his initial remarks, mentioned the fact that he had heard about these commitment discussions, but to his knowledge, he didn't know with whom or what commitment issues were being raised. You're at liberty to share who the applicants are talking with in terms of the representation of the stakeholders in the room.
I'm not sure if I'm at liberty to share. What I can say is that we are in discussions with parties and we're in discussions with other stakeholders.
Okay. Okay. Thank you, Madam Chair.
Attorney Hum, I have two I have a question, but just circling back to your response to Commissioner Karen's first question, I think you specifically enumerated the AWA board composition as something that you might be addressing in commitments, and I think your answer is yes, and I just want to make sure I heard that correctly, because I thought during the hearings that the composition of the board was specifically enumerated in statute. Did I miss something? Is that?
We're addressing that within the confines of the Special Transition Committee, and then how things may look through the Special Transition Committee and post-Special Transition Committee. That's the manner by which we're looking into that issue.
Okay, understood. Thank you. My last question here is not related to anything that we've just covered, but it was in the first round from some of the parties, there was discussions about savings and whether the savings would materialize post-acquisition, and some dispute about what the quantity of those savings might be. My question specifically is, in the public interest test, is there a threshold as to what level of savings must be achieved in order to deem an acquisition in the public interest?
I'm not aware of a specific threshold. What I can say, and to your question, we've identified through the models that have been produced throughout discovery and vetted throughout the hearing what those savings would be. That's based on Eversource's business plan that was put into that model, and that's based on other reasonable and conservative assumptions, including certain actual information. I think what we said in the briefing is, I don't think we said there's no particular threshold of savings, but I think we said if there's certain nitpicking at the 365 million that we've identified for savings, or there's certain adjustments that could be made, what we've pointed out is no matter how you look at it, there are still savings. There are still customer savings, and that much we're sure of. And that's what we think the data and the information that's in the record supports.
So there's no materiality threshold?
There's no materiality. It doesn't say it needs to be 365. It doesn't say it needs to be 200 million. I think what we're suggesting is that savings are savings. Customer savings are benefits to customers.
Thank you. Okay. All right. Thank you.
Thank you.
Attorney Canavan?
Thank you, Chair Gillette. I'd like to just underline one issue that we've been talking about, I think, throughout the day, and Attorney Hom has also talked a little bit about it. But hearing the discussion today, and certainly reading the briefs and some of the questions at the hearing, you get the impression that parties who want you to vote this transaction down want you to do so in part because Puro will no longer govern this organization going forward, that the RPB or the AWA governance scheme is not significant enough, or that the OCA is no OCC. But that vote is already taken. When the enabling legislation passed, the state legislature inherently identified those issues and identified them as a world in the future for acquiring customers that did not have pure oversight, that was governed by the AWA and the AWA RPB, and governed by an OCA instead of the OCC was okay. So this issue has already been resolved in some respects by the state legislature, and we would think there's insufficient grounds for you now to deny this transaction. That is the issue I wanted to highlight, and happy to take any questions on that issue or any others that you may have.
Yeah, let me revisit the RPB in that Attorney Hom had recently said that they have full authority to make any decisions concerning the rates. But is there anything, or is this being contemplated in terms of commitments that they will have the expertise to make decisions,
Right.
as well as the authority?
Yes, and great question, and thanks for raising that. My understanding is the RPB is made up of individuals that are appointed by each individual town, meaning that mayors will be able to identify, first selectmen will be able to identify who will sit on that RPB panel representing that municipality. And certainly there are more than one, right? RPB is a panel of individuals with that responsibility, but that group will have insight, oversight, and say in how the AWA conducts its business. From a local control perspective, that is far more than any municipality who is involved in pure proceedings. A municipality can come here. They can certainly, in a rate proceeding with an investor-owned utility, be involved. They can provide their insight, but none of them sit on the capital planning process of an investor-owned utility. They just don't. That's the company's responsibility to run the company as they see fit. Under the authority model, all those towns will be in those meetings and will be involved. And sure, some people will be more involved than others because that's human nature. But they have the opportunity to have a direct impact on how the AWA is going to be run in their service territories. So I think that you can make the argument that is far more local control than they have now. With regard to what that may look like in the future, given some commitments that were identified and maybe some that are still under discussion, I think that though that's an area that is, an area where the parties could come to see eye to eye on. I know you've been involved in many settlements. They tend to run at their own pace. It's not perfect. Not everyone's going to walk away from a settlement with exactly what they want. We are interested in resolving some of these issues or seeing if we can resolve some of these issues because we think there are some ways forward that we can do with some creative thinking inside the enabling legislation that would appease some of the issues that we've heard today and elsewhere in this proceeding. But I'm not at liberty to come up with ideas, which I can think of a few off the top of my head, in this proceeding, as that may impact the discussions to the extent they have been going forward.
Okay. One other thing has sort of been nagging at me, and Chairman Gillette started to flesh it out quite a bit in terms of the accountability of the commitments. Whatever commitments are ultimately come to resolution, what is the ability of accountability for those? Who gets to determine that those are going to be enforced? And if they're not, as opposed to just getting, hey, we're from the authority, trust us, we'll
Right.
take care of it. So how is that resolved? Is there ability for, say, the AWA towns to have access to the courts? Some other, is it could it be contemplated that the PURA, the Connecticut Public Utility Regulatory Authority, could still have the ability, or the Office of Consumer Counsel and the Office of the Attorney General, to look at some of the commitments and enforce them once they've been agreed to?
I think generally those possibilities are possible, right? I think the enabling legislation would lead the parties or the authority to think otherwise, but perhaps there's an area where some middle ground could be met. I think there's also other state agencies that oversee the deployment of safe and reliable water to customers that also play a role here above and beyond or beyond PURA, as after the transaction, it will not have its general oversight of Aquarion going forward if approved. I hope that answers your question, but please tell me if it did not.
I think it does. Okay. Thank you, Madam Chair.
I have nothing further. Thank you.
Thank you.
Okay. Attorney Ball.
Thank you. Just a few points. So on this issue of accountability for commitments, here's the one thing we know. We know that under Section 61 of the enabling legislation, PURA is out. Neither PURA nor any successor board or commissioner shall have jurisdiction of any kind over the authority, AWA, a subsidiary corporation, the Aquarion Representative Policy Board, or the rates fixed or charges collected by the authority. So it is abundantly clear that under the enabling legislation, if you actually approve this transaction, whatever verbal commitments, specific or incredibly vague, as we just heard, may be out there, are not enforceable. And they're certainly not enforceable by PURA. I have not heard a mechanism to enforce anything other than trust us. Trust us. This time we'll talk with the towns. Yeah, we've had discussions. Were they with the towns? Well, not really. We have no reason to trust that there's going to be a meaningful dialogue. Unfortunately, we are confronted with a statute drafted by the applicants that creates what I believe are irreconcilable problems. And that really leads me to the main point I want to make, which is I think the most stunning thing that I just heard from Attorney Canavan is that you can't now look at the statute and complain about it. It's done. It's settled. Excuse me, that is not what the statute says. The legislative intent of this statute was not an endorsement that you have to approve this transaction and all of those nuances. It would have said that. What it said is that it's up to you. It was an enabling legislation that had a single purpose, which was to allow RWA to bid. Okay, that's fine. RWA drafted the legislation. They came up with a bid. But the statute doesn't say it's over at that point. Could have, doesn't. What it says is that you, Pura, are the arbiter. You are the one to decide. It is abundantly clear. The nuances, the record here, all of these issues were never vetted at the legislative process. The legislative process was step one, to allow RWA to bid. The real process to determine whether this transaction is in the public interest is solely in your hands. So I absolutely reject any suggestion that our unhappiness with the fact that they stripped away the prudency requirement, that they stripped away any meaningful consumer advocate, and that they stripped away your involvement is something that I can't raise now. That goes to the heart of what the problem is. They drafted the statute in a way that favored them, but it certainly doesn't favor ratepayers. Now, just on the issue of what's in the public interest is consent required. It's true. The language of their enabling legislation does not say we got to get the consent of the municipalities. But, and I think Attorney Hum said, well, the real test for public interest is really what's the impact on ratepayers. Respectfully, that's why we're here. Okay, we are here. The municipalities are here because of our deep, deep concerns about the adverse impact on ratepayers. Okay, so whether they sought our consent or obtained our consent, the absence of our consent is absolutely something that you must consider as being not in the public interest. We don't believe that self-regulation is in the interest of ratepayers and therefore not in the public interest. We don't believe that eliminating the prudency requirement is in the public interest, and it's certainly not in the interest of ratepayers. Same with OCC. The issue of local control is getting a little bit circular. I think we've established very clearly that the AWA Representative Policy Board will be the same rubber stamp for the recommendations of management that the RWA Representative Policy Board is. There is no reason to assume that there would be any independence. They are going to be completely dependent on those recommendations, which might explain why every single rate application in the RWA was approved by the RWA RPB. And I'll just finish by saying the idea that you know, the savings might be 300 million, maybe they're 100 million. Materiality is not really an issue. The entire premise of savings for ratepayers is that in the alternative, you, Pura, will rubber stamp every rate application that Aquarion brings before you. So it's true. If I take Aquarion's wish list for the next 10 years of massive rate increases, and I assume that you're going to approve that, well, I can probably come up with another model that shows it might be a little cheaper. But there is absolutely no basis to assume that you are going to change the meaningful regulatory oversight that has characterized Pura since its inception and suddenly approve everything Aquarion puts before you. So I just reject that there are savings, certainly nothing in the record that we can rely on to assume any savings for ratepayers.
Thank
Happy
you.
to take any questions.
Anything further? Nothing further. Thank you.
Thank you.
Attorney McLeod.
Thank you, Madam Chair. Just for the record and to make clear it's there, I've heard the references by the applicant's attorneys to the fact that they're working toward commitments and they've got a transition committee, et cetera, and they're working. It was implied with parties. Nobody has contacted MetroCog or to my best knowledge, the towns within the MetroCog area. I think I would have heard about it had that been the case. But I wanted to comment on a couple of things. One is the issue of consent again. You know, it was stated in the application and in testimony that the creation of AWA mirrored the creation of or the governance structure, et cetera, of RWA. And if consent was good enough for RWA, I don't know why it isn't good enough for AWA. So sidestepping that issue because, as Mr. Hum put it well, that was in RWA's enabling legislation, but it's not in AWA's enabling legislation, just draws attention to the fact that the applicants drew AWA's legislation and left any element of consent out. That is a key difference between the two creation stories. I have heard references by Mr. Hum, I believe, to the fact that credit agencies have viewed the deal favorably with RWA's involvement. What I have not heard is whether the question was put to any of the credit agencies about what their view would be without RWA's involvement. Would the credit rating of AWA alone, without RWA's seats on the board, whether it be 2 seats, 8 seats, however many, would they still get a better deal than what the applicants are saying Aquarion Water Company would be able to get? We don't have an answer on that. To my best knowledge, there is no testimony in the record about whether or not rating agencies were asked that question, and if so, what their response was. So I think that's something you can take into account, because they're just assuming that you have to have RWA in to get a better deal. I don't really understand why it takes so long to come up with a conflict of interest policy. This is an issue they've been aware of for at least a year at this point. Or maybe they weren't. I take that back. They may just have found out about it during the course of these hearings, that this was an issue to the towns and to people in their service area. But if so, it seems to me that attention should have been given to a fairly key point that got a lot of attention during the hearings. And the idea of coming to you afterwards, playing games, really, with the fact that maybe you have the right to go after it after approval, and maybe you don't, and making commitments on some kind of a list through a transition committee that we are not a part of. I think that must be an internal committee. I think somebody else said it. We don't place trust in those promises. And we won't have anybody to go to for recourse if those promises are not met. In terms of legislation and changing legislation, it strikes me that if towns, the public, and the applicants all went together, hand in hand, to the legislature and said, hey, we have some changes we'd like you to make, I would have to think that would get some traction in terms of getting passed, and that amendments would be made. There has already been one amendment to 25-1. I think it was maybe in 25-7 or something, but there was one somewhat minor change, an amendment made, and there's no reason to think that another one couldn't be made. I think my last question is, I haven't yet heard a compelling reason why RWA is sticking its nose into AWA's business and operation. That is not the model that has been set forth in any prior authorities in the state of Connecticut. All of the other water authorities have been created by legislation and stand on their own without outside assistance, without transitional help, without board control from elsewhere. And there's no reason really why that can't be the case with AWA. And if there were truly savings to be achieved, that could be done through an AWA-only model, it would seem to me. We haven't heard any evidence that it couldn't be done. I think that wraps up what I have to say.
Any questions?
Thank you.
Nothing further. Thank you, Attorney McLeod. OCC, any rebuttal?
Thank you. Noticing the time and just a few brief points. Regarding our overarching concerns on the financial impact to Aquarion customers of this transaction, we understand the basic contours of AWA's argument that AWA can access cheaper capital, so the capital costs passed down to customers are supposedly lower. But our primary concern isn't the ongoing capital investment, it's the cost of the acquisition itself. We hear the applicants promising that the AWA can pay almost twice as much as the book value of the system without negative impact to ratepayers. And frankly, we just don't understand how that's possible. We feel that we've attempted to understand it through discovery and cross-examination in the hearings, but to this day, we continue to have questions about the comparative models. And that's the point we want to emphasize today, that it isn't enough to say that this is just a better deal. The applicants need to prove it. And from our perspective, there are still more questions about that than clarity. I believe that there was some discussion from Attorney Hum about some changes or ongoing discussions that could be dealt with by October 1st. If the applicants are suggesting a settlement is possible by October 1st, and I'm not clear that that's what they're proposing, but if it is, the OCC can definitively say that that does not seem like a possibility, particularly given the fact that the towns have just confirmed that no discussions have taken place between them to date. And to our last point, Attorney Canavan argued that the issues of PURA oversight and OCC are foregone conclusions because they are already in the statute. However, the statute only created the AWA framework and left the determination of whether that framework is actually in the public interest to PURA. So while it may be true that these issues are unresolvable so long as they are in statute, we actually see that as weighing against the transaction rather than in favor of it. And we agree with Attorney Ball that the legislature clearly gave PURA the authority to evaluate whether the entire transaction, including the governance structure, is in the public interest. Take any questions if there are any?
Can you say that last point again, please? So your position is that while the legislation has put forward a certain governance structure, it's the OCC's position that the legislation does not opine on whether that governance structure is in the public interest, but rather places that determination with PURA. That's the OCC's position.
Yes, I would say that it's PURA's responsibility in this transaction to look at the application as a whole and determine whether it is in the public interest, and the governance structure is part of that.
Thank you. Is there something specific in the enabling legislation that supports that led you to that conclusion, to that position, rather?
If the authority could give me a moment to confer,
Please.
Thank you. Thank you. I believe if I could turn the authority's attention to section 42, in which it says Sections 34 to 41, inclusive of this act, shall not be effective unless the Public Utilities Regulatory Authority approves the South Central Connecticut Regional Water Authority or the Aquarion Water Authority to own and operate the Aquarion Water Company or one or more of its subsidiaries.
Thank you. Any further questions? Nothing further. Thank you. All right, last but not least, Attorney McCormack, please.
Thank you. Just a few points. To start, this has not been resolved unless the legislature meant to make peers review meaningless here. As Attorney Ball highlighted and the OCC highlighted, the legislation was meant to allow the RWA to make a bid. The RWA has made that bid. The bid is now in front of the authority to evaluate. The statutory standard is General Statute Section 1622, that the public interest, that requires that the transaction is in the public interest and places the burden of proof on the public service company to demonstrate that. It is clear that the applicants have not done this and the application is deficient. The towns have hired attorneys that appeared here, and the towns and municipalities are proxies for the public interest and have made their feelings known. Their voices are critical. I welcome any questions.
Nothing further.
Thank you.
Thank you. That brings us to the end of today's oral arguments. I want to thank all of the parties, participants in today's oral arguments, and those who did not participate today but who provide briefing on the matter. Pura will take under consideration the entire record, the briefs, the reply briefs, and today's oral arguments and rendering a decision, which will be made available in the docket. So thank you and have a good rest of the day.